All right, we are back. We're back. Welcome back to the Court of Public Opinion. If you're just joining us or just finding this on replay, we just jumped for another live stream. We're about to jump into Thurston County, where we're watching the very beginning of a short trial where a woman is charged with reckless driving. Join with us. This is one of our fun courtrooms we like to go watch. Buckle up. Let's get going here as the jury is just now walking into the courtroom. Let's see if we can go there live.
Good morning, members of the jury. Welcome back. And when we broke yesterday, we heard opening statements from the attorneys. And so, Ms. Kidmacher, you may call your first witness.
Your Honor, the state is calling Sheriff Derek Sanders.
I didn't know we missed opening statements. Oops. They deleted them.
Can you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You may be seated.
Thank you.
And Ms. Kidmacher, you may inquire.
Thank you, Your Honor. Good morning, Sheriff.
Good morning.
Can you please state your name and spell it for the record?
Yeah, my name is Derek Sanders, DerekSanders.
And what is your current occupation?
I am the elected sheriff of Thurston County.
How long have you been in law enforcement?
Since July of 2014 is when I first got into law enforcement. I've been commissioned since January of 2017.
And in what county and state are you a law enforcement officer?
I am a law enforcement officer in Thurston County, Washington State.
Were you a deputy sheriff first?
I was.
And what kind of training did it take for you to become a deputy sheriff?
So after being hired as a deputy sheriff, I spent 6 months at the Basic Law Enforcement Academy, which is where they cover all of the basic elements of law enforcement. That's traffic investigations, collisions, assaults, criminal procedure, criminal law, defensive tactics, driving operation, all of those types of basic law enforcement aspects. And then once you graduate the academy, you then spend just short of 4 months in the field training operations program. So that is where you have a field trainer, a certified trainer with you in the car, and they are grading everything that you do. And that occurs for about 3.5 months. And then there's a final check ride where you are basically unassisted with a sergeant in the vehicle who observes your week and ensures that you can do all the basic functions of a law enforcement officer.
Was there additional training required for you to become sheriff?
No, that's the bare minimum.
Okay. Do you have any specific training on reckless driving investigations?
I've done a number of different classes for street crimes, which includes different types of traffic infractions and different driving violations. And then again, we just get our normal refresher from the prosecutor's office for our legal guidance on traffic infraction enforcement.
How about reckless endangerment investigations?
That is covered at the Basic Law Enforcement Academy in terms of what reckless endangerment is, how to achieve it through criminal law, and then case law that supports it.
As sheriff, what are your primary duties?
Well, I have some very high-level duties. I'm ultimately responsible for the $58 million budget associated with the sheriff's office. I have 4 bureaus. That includes the Field Operations Bureau, which is the patrol. That's going to be your most visible. I have the Support Services Bureau, which is our detectives. I have the Finance Bureau, which controls all of the finances through the sheriff's office. And then the largest bureau is the Corrections Bureau. I'm also in charge of Thurston County Jail.
Are you still working as well as a patrol officer?
Correct. As the sheriff, I still routinely go out and conduct law enforcement.
Does that include investigating traffic incidents, collisions, DUIs, reckless driving?
It does, yeah. The sheriff's office has taken a very proactive stance for traffic enforcement.
Wendy was first
in chat. Were you on duty as a law enforcement officer on March 14th, 2025?
I was.
And where were you?
I would have been on Rainier Road in Thurston County.
And is that Thurston County, Washington County we're currently in?
Yep, Washington State, Thurston County.
Do you remember seeing anything out of the ordinary while driving on the 13,500 block of Rainier Road Southeast?
Yes.
What did you see?
The first thing that caught my eye was I was peering through my driver's side mirror, as I commonly do, to see traffic behind me, and I noticed that there was a vehicle driving the wrong way down the road.
So where were you in relation to this this vehicle you saw?
I was ahead of the vehicle.
You're ahead of them, and you said wrong way down the road. So what does the road look like? How many lanes is it?
It's a 2-lane road. It's very rural. It's the 13,500 block of Rainier Road. So for those of you familiar with it, after you come out of the cell phone dead zone, of Rainier Road and you're heading towards Rainier southbound. It's basically after you clear the JBLM property and you're back into what looks like residential area. It's a 50-mile-an-hour zone through that area. And it just looks like rural county. So you've got houses, farms, fences, mailboxes, all the normal rural county aspect to it.
So I want to back up a little bit. You said you saw out of your driver's side mirror a car in the other lane. What happened next?
It was very clear to me that they were probably passing. That's the only logical reason I could come up with as to why a car would be in the oncoming lane. What did catch me off guard was how long they were in the oncoming lane, which led me to believe that they were passing multiple cars. So that was the first piece of what caught my attention.
So your vehicle in relation to this car, did they pass you?
Eventually, yes.
Okay. And so you saw them pass you?
Yeah. So after I lost sight of that vehicle, it pulled in behind. There was still at least one car in between us at this point. So I lost sight of that vehicle that was in the oncoming lane. And then just a short time later, I then observed that vehicle conduct a double pass around the vehicle behind me and me.
So by double pass, you're saying two cars that passed two cars?
Correct.
Okay. And after it passed the car behind you, and then as it's passing you, what do you see?
At this point, I became very concerned. There was oncoming traffic. And so I observed in very quick time that the vehicle that was conducting the pass had to hit their brakes. They did not use a turn signal as they pulled in front and cut me off to avoid what appeared to be a head-on collision for the vehicle that was coming the other direction. And at that point, I observed the other vehicle coming the other direction also slam on their brakes and pull off onto the shoulder, almost into like someone's driveway to avoid a collision.
Okay. And after they pull back in front of you, what happens?
Well, I was naturally very caught off guard, so I just immediately activated my emergency lights and conducted a traffic stop.
Naturally.
So you mentioned the one car in the oncoming lane. Was there other vehicle traffic on the road? Yeah, there were vehicles. You know, it was midday, so you've got vehicles going both directions. There was a car way ahead of me. I believe there were at least one or two more cars further down the road from the vehicle that had to slam on their brakes. You had people waiting to turn off of 133rd just behind us. And it's not uncommon for people to be pulling out of their driveways around that time of day as well. So you said you turned on your lights. Did the vehicle pull to the side?
It did.
Okay. And what happened after that?
I contacted the driver. The driver provided me license, insurance, registration, and I called for a second unit to come assist me.
Is that how you identified them with their driver's license?
Correct. Photo ID.
Okay. Looking in the courtroom today, do you see that person who was in the driver's seat who you identified here?
Yes.
And who do you see?
She is sitting here at the defense table. She's wearing a pink top and has her hair up in a ponytail.
And what is her name?
Emily Fogelman.
Let the record show Sheriff Sanders has identified the defendant, Ms. Fogelman.
It will.
Thank you. One, please.
Okay, not a good start for the defendant. Passing cops. It's just a challenge.
And Your Honor, permission to approach the witness.
You may.
She's drinking the
Showing
iced
you
pumpkin
a flash
spice
drive, which has
latte.
been marked as State's Exhibit number 1. Do you recognize this flash drive?
I do. That is a flash drive that I have signed as containing the contents of my dash camera and rear-facing camera on my patrol vehicle.
And how do you know that that's what's on that flash drive?
You showed it to me.
And is it a fair and accurate representation of what you saw on March 14, 2025?
Yes.
State would move to admit and publish the jury.
Any objection?
No objection, Your Honor.
I
It'll
don't,
be admitted and you may publish it.
Thank you.
I've got my fingers crossed, but I don't think we're going to see it. The TV they show it on is, I don't think, connected to Zoom. It's that one right there. We get that little side, which might be the side we want, honestly. That might be the side that we can see her pass on. You got to look closely. We never see the evidence in this one. Maybe they'll describe it in detail like we're blind. That would be great. Lots of drinks. Somebody's super thirsty. 6 6 containers of water there on the defense table. Defense attorney trying to get a good vantage point from back in the cheap seats. This is why I don't think we're going to see it. Yeah, it's rare to see the witness as well here. I'm glad they've got that mic activated. Little twiddling of thumbs as we wait. Does look like the person behind her is probably supporting her in this case.
The forward-facing view from my patrol vehicle.
We can't hear jack squat.
This is rain.
I think I have a sound effect for that. There we go. So, if you were in the courtroom and jury member, what you would be seeing right now is cars driving on a road, 2-lane road, looking out the front dash of a police vehicle, and cars coming the other way. And then you now see passing on the left a car passing the police officer as cars are coming towards it and having to swerve off the road and pull off traffic a little bit. And now you're going to hear some audio. Well, maybe they will. Officer flips on the lights and effectuates a stop. It says, "Excuse me, ma'am, do you know I pulled you over? It's just about killed those people back there. Made them drive off the road." Objection, imaginary evidence. Not guilty, says Josh. I could not convict. I don't know, maybe she's still trying to launch the file. Nope, she's pausing. I think she's done here. Need some chase music. Hang on. Yeah, it's going. This is actually the sound that the officer had going in his car. This is the radio station he was listening to. Sheriff, the actual sheriff, not an underling, not a deputy sheriff. This is the sheriff. And she's stepped so far away from the mic, we can't even hear her questions. We get the yeps.
A little bit of a strange view. This is the cage camera for my patrol vehicle. So with our old camera system, I had a cage camera. I have a split cage inside my vehicle for people who I'm transporting to jail or just transporting in general. And so there's a camera that faces the actual cage there. I didn't even realize this, but it actually does capture out the back window as well. So that's why I'm assuming it's being presented today. So the reflection is because it is on the other side of the plexiglass. So you're getting a reflection back to the driver's seat essentially. But through the back window, you can actually see traffic light. Correct. Correct. Yeah. The reflection is off because it's going to be the opposite. So it looks like I'm driving a right-hand side car. But that is the same vehicle that's referenced in the main video.
So you talked about this a bit, but what is the area like where this happened specifically?
Objection asked and answered.
Overruled.
What is the area like where this happened specifically?
It is a rural area. It is an area with very little cell reception. It's coming off of a JBLM property, which is basically just maintained for training purposes for forestry. And then as you approach southbound on Rainier, you essentially have a couple main cross streets that come off of it. All of the speed limits throughout that area are 50 miles per hour, with the exception of once you come into the city limits of Rainier, it slows down to 25 miles an hour. Rainier is a small town. I would venture to guess it's less than a few thousand people, maybe 1,000 people total. So very rural area.
The point that we saw the vehicle pass, you're within Thurston County, Washington. Is this considered a high traffic area?
I would say Rainier is a high traffic area. There's throughout that district, that patrol district, there's anywhere from 30 to 40,000 people, and many of them use Rainier Road as the main nexus to get to the Tri-Cities of Olympia, Tumwater, Lacey. I would say, me personally, I commute Rainier Road every single day, multiple times a day.
And you mentioned the speed limit is 50 miles per hour on that stretch of road. Do you know what speed you were going?
I was going 53 miles per hour when I looked down at my speedometer when the defendant passed me.
Do you have training experience determining the estimated speed of a vehicle?
Yes.
What did that training look like, and what are the various methods that you might use to do that?
So some of the really basic math is that a car can't pass you unless it's going faster than your speed. So that was the first thing that makes it very easy to determine if someone is going slower or faster, is to simply verify your speed and then compare it to the relation of their vehicle to yours. The second piece of this is that all of our vehicles are equipped with a radar device. The radar device was not used in this scenario, but I would say that it lends to the experience that for the last 9 years of my career, 8 years of my career, every single day I have my radar running, and I'm constantly watching vehicles and being able to verify how fast they're going. So naturally, that experience allows you to have a good understanding within usually 10 miles an hour or so of how fast vehicles are going, to the extent where, in my current experience.
Objection, narrative response.
Okay. I'll sustain the objection. You can ask your next question.
So based on the training experience you're describing, were you able to conclude anything about the likely speed of the defendant's vehicle when it passed you?
Yeah, I estimated the vehicle was traveling approximately 75 miles per hour to conduct a double pass at that rate.
Zoom.
Were you able to estimate the distance between the car that we saw in the oncoming lane and the defendant's car?
I did not estimate that. I would say, based on what occurred, probably a few hundred feet.
No.
Mr. Stashevsky, you may cross-examine.
Thank you, Your Honor.
Go get him, Tiger. Tears a page out of the Trapper Keeper. And
Sheriff Sanders, I'm Andrew Stashevsky. I'm the defense attorney for Ms. Fogelman. If I ask a question that is confusing or doesn't make sense, just let me know and I'll try to rephrase, and I'll try to, in the first place, not ask confusing questions.
Yes, sir.
Kind of like to first start at just working in kind of a chronological order, the start of the interaction. There was a car immediately behind your car, correct?
Yes,
okay.
Sir.
On direct, you testify that you believed Ms. Fogelman was traveling at approximately 75 miles an hour when she passed. And that was a visual estimate.
Correct.
There wasn't a radar detection of her speed at that time.
No, there was not.
And I believe you just testified a matter of moments ago that you believe the approximate distance between her vehicle and the vehicle in the northbound lane traveling in the other direction was, you said, a few hundred feet, I think is what you. Okay.
Yes, sir.
Kind of speaking about the conditions of the roadway when this took place. This took place at roughly 2:30 in the afternoon.
Yes, sir.
Thank you. And the moment where she passed you and the driver behind you, at that moment, it was not raining.
It was not.
The roadway was not wet at that time.
It was not wet.
Stricken, log out and
Is
jump
it
back
fair
in.
to
Just
say,
refresh your page.
kind of given the timing of when this took place, that visibility conditions were pretty good?
Yes.
And the portion of Rainier Road Southeast where she passed you and the other driver, is it fair to describe that portion of the roadway as a straightaway?
It is.
There's no, sorry, I didn't mean to step on your toes. There's no bends or turns at that point?
That's correct.
Okay. And at the point at which she passed you in the car immediately behind you, the northbound lane and the southbound lane were separated by dashed yellow lines.
That's correct.
And that generally indicates that if outside of this situation, just generally, that would be a passing zone.
Yes, so long as it's safe to do so.
So long as it's safe to do so, you can pass. Where this took place, the northbound lane and the southbound lane were not separated by a solid yellow line.
They were not.
And a solid yellow line would indicate a no passing zone.
That's correct.
When you saw Miss Fogelman, I appreciate at that time you didn't perhaps know who it was, but when you saw this car passing you and your vehicle entering the other lane, did you slow down at all?
I don't believe I slowed down. I pulled slightly to the shoulder to try to create as much space as I could.
And from your perspective, kind of now switching topics, talking about that car in the northbound lane traveling the other direction. From your perspective, kind of where you were, you could not see the brake lights of that other vehicle.
No.
And on March 14th of this year, when these events took place, did you have a conversation with the driver of that other vehicle?
I did not.
Did you have a conversation with the driver of that vehicle after these events took place?
Not able to locate them.
Okay.
They didn't stick around?
During this interaction, these events, it did not appear that Ms. Fogelman was racing another vehicle?
No, I would not call this racing.
It did not appear that Ms. Fogelman was engaging in road rage or anger or anything like that?
It would depend on what you classify as road rage. Could you clarify?
Objection, speculation.
I'm going to overrule the objection. You heard his response. You can ask your next question.
There were no injuries as a result of this factual occurrence?
Objection,
No.
relevance.
Overruled. This is cross-examination, and so you can continue.
And I'll ask the question again, just so we're all on the same page. There were no injuries as a result of this factual occurrence?
No physical injuries.
And a traffic accident
Was
did not
there
occur
emotional
because
injuries?
of this?
Did you get your pride wounded, Sheriff?
Now, after Ms. Fogelman passed you, kind of taking one step forward, talking about the effectuation of the traffic stop. After Ms. Fogelman passed you, you effectuated a traffic stop.
That's correct.
You were in a sheriff's deputy car, is that correct?
Yeah, I was in my patrol vehicle.
Was the car marked? Did it have sheriff's deputy markings on it, or
Just on the back.
just on the back? Okay. After Ms. Fogelman passed you, you turned the patrol lights on.
I did.
Is it fair to say that you turned the patrol lights on fairly quickly after she passed you?
Yeah, it was almost a reaction.
Okay.
Wow.
And this is a silly question, so don't laugh at me, given some of your direct testimony. You've effectuated other traffic stops in the past, correct? In your experience, when a law enforcement officer is effectuating a traffic stop, they have their lights on. Do other drivers, generally speaking, if they're able to do so, give the law enforcement officer space on the roadway?
Sometimes.
Sometimes.
Yeah.
But you have seen that before?
Yes.
Okay. Is there actually a legal requirement that other motorists give law enforcement officers space on the roadway if they're able to when they're effectuating a stop?
Yes.
Okay. And then now kind of talking about stepping forward one more time, talking about your interaction with my client. After you effectuated a stop of Ms. Fogelman's vehicle, you had an interaction with her.
Yes.
You obtained her license and registration.
Yes.
Now, there's no body cam footage of your interaction with Ms. Fogelman. Is that correct?
That's correct.
And is that because you were not in your patrol uniform that you're wearing today? You weren't wearing that on the day that this took place?
Correct.
You were in civilian clothes?
Yes.
And so you called another, I think after that initial interaction with Ms. Fogelman where you exchanged the license and the registration, you called another sheriff's deputy to respond.
Correct.
Do you recall his name, that other sheriff's deputy?
Deputy Stevenson.
What is Deputy Stevenson's first name, if you remember it?
It's Zach.
Zachary?
Zachary.
Is it fair to say that your interaction with Ms. Fogelman was, your interpersonal interaction with her was fairly short?
As short as I can make it, yes.
Did you make it short in part because you weren't in a patrol uniform?
Yes, yeah. That's why I immediately asked for a second unit.
Would you be surprised if the dash cam footage showed that your interpersonal interaction with her was like a minute and a half or 2 minutes in total?
That would seem long.
That would seem long?
Yeah.
Okay.
I would say it's shorter than that.
I can write a ticket in 45 seconds.
Do you know how much time Deputy Stevenson spent with Ms. Fogelman? Even just a rough?
I don't believe it was very long.
Okay. Is it fair to say that it would have been a longer interaction than you had with her?
Yes.
Okay. And Ms. Fogelman was arrested at the end of this event on that day, and her car was towed?
Yes.
No further questions. Thank you.
Thank you.
Any redirect, Ms. Kitmacher?
Yes, Your Honor.
Was this a legal pass and he was just butthurt that she passed him?
You mentioned that you could not see the brake lights of the oncoming vehicle because you were not on the side of their brake lights.
Correct.
But you also mentioned that they did brake. How do you know that?
Yeah, so one of the things that you get a lot of training on is vehicle operations and how vehicles work and the dynamics of vehicles. So when you can see that the suspension is loaded to the front of a car, that's evidence of braking. When you see a vehicle rapidly decelerate and you're not approaching them as quickly as you were, that's evidence of braking. The maneuver to pull to the side of the road, turning automatically will naturally decelerate a vehicle when you turn. It creates more resistance on a vehicle than if you're going in a straight line. So all of those things combined led me to establish they had rapidly decelerated.
And at what point in this other vehicle passing, and at what point did that other car appear from your perspective to move to the side?
As quickly as I could unfold what was occurring, when I looked at the vehicle that was traveling northbound, it appeared almost immediately that they had recognized there was a vehicle in their path of travel and were already starting to decelerate and pull to the side.
And why weren't you in your uniform that day?
I apologize. I didn't hear the question.
Oh, why were you not in your uniform? You mentioned that you were in civilian clothes.
So Fridays are normally my day off. I did have work that day in the morning, and then I stopped at the gym on my way home. That's usually the one day I get some exercise. So that's why I was in gym clothes.
No further questions.
Any recross, Mr. Shashevsky?
Nothing additional, Your Honor.
Okay. And then may this witness be accused?
Your Honor, I'd like him to remain.
No, he can remain, but you can go back and sit at council table. You're free to go, but you're also free to stay. So go ahead and.
Thank you, Your Honor.
Yeah, of course.
Subject to recall. And now?
And then Ms. Kitmacher?
Your Honor, the state rests.
The state rests. Done.
So members of the jury, the state is rested. We're going to take a break. I'm not sure how long this break is going to be. but it'll be at least 10 minutes. And so the clerk is going to take you back into the jury room.
Told you it was a quick one.
We'll be back in session in a few minutes.
Let's see if they kill the live stream if we get to hear the argument for judgment of acquittal, which should come right now. I like how they have tissues at the witness stand for the cop who got passed by a nice lady. Shortest trial ever.
Mr. Krzyzewski, does your client intend to testify?
Your Honor, I would like an opportunity to discuss that with her really quick, if
Okay.
I may. Yeah, please.
Excuse me, you may. We're going to take a break. I'll come back in about 5 minutes.
Thank you, Your Honor. This is the restroom. Go upstairs, and I'll meet you in the breakout room upstairs. Not sure.
Better to meet in the breakout room than the restroom. I'm just saying. I don't think they did a JOA. Not a huge deal here, but I thought we were going to have two. I thought we were going to have two officers. The other officer, the responding officer, might have testified. The second one, the backup, you know. Is she out on bail? Yes, most assuredly. Probably personal recognizance. Just, hey, you're going to show up for court, right? Good. All right, we'll see you then. But she was arrested and car towed. I mean, that's pretty major. It's pretty major. She got booked, then released promptly. I am feeling a bit of ego from the sheriff. I like this guy. I think I actually follow him on Twitter. Or maybe that's Pierce County. I can't remember. I feel like there's more to this story on his side than just like I was driving home from work, off duty from the gym, and man, I couldn't help it. I saw a crime and I knew I had to do something about it. I had to flip on my light and like, whatever, it's my day off, but I'm the sheriff. I got to set an example. No, I think he saw this lady passing and was saying, you don't pass me. I'm the sheriff. You know, I enforce the rules here. The whole somebody else swerved off the road and they just didn't stop. They almost caused an accident, almost killed them, but I was not able to locate them. We're in Washington. I think it is a power trip. You know, I mean, I'm a huge supporter of law enforcement. I don't. She wasn't reckless driving. I mean, she wasn't racing. There was no road rage. She's not like flipping people off as she's going by. You know, take that, sucker. Use a skinny pedal. No, there was none of that. And she's just passing cars, and he's going under the speed limit, right? He's in a 55, doing a 53, and she's passing. In a passing zone, right? It wasn't a no passing zone. He just didn't like how fast she was doing it. Yeah. Hands up if you ever passed more than one car at once. I have. There's a straight stretch on the way out to the beach, headed to Atlantic Beach from my house, where you can see for about 3 miles. And when you've got Farmer John pulling his trailer full of tobacco leaves up front, and you've got 6 people behind him that think that 20 miles an hour is a great speed for a 55-mile-an-hour road, I'm passing. Zoop, all of them. Here we go. I'll do it. I won't do it at like 100 miles an hour, but I'm passing them. Yeah, Sheriff Sanders. Then he guesses how fast she was going. He doesn't get a speed on her because he had the lights on before she pulled in front of him. He was ready and waiting. It's like right when she's parallel, whoop woo, makes the little whoop-de-woos happen, and then they pull her over. She didn't have a chance to get clocked on his radar. Getting my story straight in advance. Okay, so it wasn't. Maybe there was no farmer, and maybe there was no trailer of tobacco leaves. It could have been Carn. Could have been Carn. It's Carn, like that. It could have been collards, for all I know. He was jacked up from his epic workout, says Stevie. You work so hard to pass everyone. Then the wife has to pee, and you watch everyone pass the wayside. Oh. Yeah. The video, yes, the video could show a lot more. And if this is a really quick verdict, it probably does. I know, we do that. We're going to talk about things that are not relevant tonight on the podcast, the Not Relevant podcast tonight on this channel, 8 p.m. Please join us. Thomas and I will be here with a special guest. Having some fun, talking, probably telling some really pathetic jokes as well. He's looking in the mirror that says objects in the mirror may be closer than they appear or something, and he's judging his speed from that while he's driving the other direction. Like he's like, whoa, yeah, she's doing 75 at least. I don't know. Okay, come on back. Folks, come on back. You've had enough time to talk. Are you going to testify, ma'am? Maybe you should. Of course, if you do testify, the state will call the officer on rebuttal. That's why he's been held here. I think it's worse the fact he's off duty. Yeah, it makes you feel like he wanted to do this, right? He didn't have to. He wanted to. Maybe somebody outlifted him at the gym, right? He was doing his bench press, and he put on the big boy weights, and he does his personal best on the rep, and then somebody comes and you're like, "Are you done with that?" And they add like the big ones, and then they keep using it like it's a play toy. Maybe that had just happened. And in gym shorts, so he could flex. If I keep talking like this, I can never drive through this county. You know that. I'll be like banned. They'll add me to the blacklist. I'll be pulled over in the Gore Point and imprisoned for the rest of my life in Thurston County. I love Thurston County. We're just having a little bit of fun here. This is obviously it's a case I feel we can joke around a little bit more with, where there was no injury. There's nobody who got hurt. It seems like a very light penalty. I think at the end of the day, although there could be a maximum penalty involving incarceration, I doubt that would even be used in this case. It just doesn't seem like it's risen to that level. It's most likely going to be a fine and points in the license at most. Groovy Cheryl, I interviewed for sheriff once. I promised the legal limit is the legal limit. No editing. LOL. It's actually dangerous to pass an officer because you don't know what they may be observing. Then drive faster. So, don't go under the speed limit. I realize the speed limit is the upper limit, but you're impeding traffic, which is also an offense, right? You can pull someone over for impeding traffic, for driving too slowly. Always helps to have some levity around here after a heavier trial. I agree, Josh. Thanks for helping us find this one. Why is the cop the bad guy? She was speeding. Could have hit a person or pet driving over the speed limit. I don't know. The cop's a bad guy. The cop could be a really great guy. He just came across as just to me. I just got. You know how jurors are able to use all their senses to determine if somebody's telling the truth and everything. He just comes across as cocky, and it just my spider sense was tingling a little bit. That's all I can say. I think he's great. I'd love to go on a ride along with him. Yeah, not in the cage. Tash says, when I'm not watching court trials, I love to watch First Amendment auditor and lawn maintenance videos. So you can run like two side by side. It's funny because there's actually some overlap between those two with when the police get involved with the lawn maintenance guys. Like, you don't have a permit to be working here. It's like, really? What I've learned is police really have no clue of the actual law, just the enforcement part. I think I wouldn't say that much. I'd say most officers are fairly well versed in the law. There might be areas of the law where they're not as familiar. And there's a lot of public perception and common belief that people mistake for law. Say, for instance, you don't have the right to film me. I'm in a public place, but I didn't give you permission to film me. Guess what? The Supreme Court did. Live with it.
Jury back in. Defense would have a motion. Oh, I'm sorry. Are we?
We're not on the record. Go ahead. Go ahead.
Your Honor, just to make a motion for a directed verdict on the basis that no reasonable fact finder could return a guilty verdict on these specific facts. Specifically, Your Honor, the road conditions, that it was a passing zone that this took place in. And I don't believe any evidence has been adduced to those higher standards for reckless endangerment or reckless driving.
Granted, Judge. Granted.
Ms. Hedmacher?
Yes, Your Honor. The state would, of course, object to that.
You don't object, you respond.
It is a reasonable fact finder could certainly conclude that the testimony, the video, demonstrate reckless driving. It's fact sufficient to show reckless driving and reckless endangerment. That it was a passing zone and that the weather was okay, frankly, are irrelevant, but not relevant here when you see on the video the passing multiple vehicles, the other vehicle pulling to the side of the road based on the defendant's behavior. A reasonable fact finder could determine that amounts to reckless driving and reckless endangerment for the passenger in her vehicle, and they should be afforded the opportunity to determine that.
With regard to, there's two charges here. With regard to the reckless driving, the motion to dismiss will be denied.
Okay.
I do think there is sufficient factual basis where this can get to the jury. The driving pattern was described fairly detailed. I think a jury could find. I'm just going to leave it to the jury to make that decision as to whether or not that amounts to term of reckless driving. With regard to the reckless endangerment, the complaint alleges.
Just going to sustain this one. It's getting thrown out.
Reckless.
This is a JOA or directed verdict. It's the same thing. It's just called different things in different states.
Reckless endangerment refers to another person, to wit, and then is named Hunter Fogelman. I didn't hear that it was ever established, was never in evidence that there was a passenger in the car or named. And so that's, without that evidence, I don't think a jury could find reckless endangerment when they never heard there was a passenger and they never heard who the passenger was. And so the reckless endangerment, the motion with regard to the reckless endangerment will be granted. The only charge, again, I'll get to in a minute, but the only charge that's going to go to the jury is the reckless driving.
Yes, Your Honor.
And then now, is your client going to testify?
No,
Yes, Your Honor, we will call Ms. Fogelman.
Now she would.
Yep. Okay, we'll bring the jury back in.
Okay, here we go. Yeah, I think it's her son. I believe he's special needs. I recognize some of the behaviors from family members I've got that probably in the car with her, the one who's there behind her. Let's see, grab Ashley's comment. What did Ashley say? Or when did she say it? That one right there. Melanie the Little just gave you big compliments about your channel. That is awesome. Appreciate that. That's really cool. Tell her thank you. It's been a while since I've been on.
So the jury, when we broke, the state had arrested Mr. Sashevsky. We may call you the first witness.
Your Honor, defense would call Miss Emily Fogelman to the stand.
And Ms. Fogelman, you can come up, you can come around.
So we saw the rare granting in part of that directed verdict or judgment of acquittal.
Would you raise your right hand?
Throughout half the charges.
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yeah.
You can be seated.
She's like, yeah. Christine,
Mr. Shashevsky, you may inquire.
Pull it
Thank
straight
you,
from Thurston County
Ms.
Courts.
Fogelman, can you
Courtroom
introduce
4.
yourself to the jury?
I'm Emily Fogelman.
And then jumping right into it, Ms. Fogelman, where were you on the afternoon of March 14th of this year at approximately 2:30 p.m.?
I was driving my son home from work.
And what happened at a moment during that drive home?
I came upon some vehicles.
And what did you do after coming upon those vehicles?
I saw that there was a passing zone, so I took the opportunity to go around them while I had broken the yellow line.
Was it safe to pass those two vehicles at that time?
Yes.
Why do you believe it was safe to pass the two vehicles at that time?
There was nobody coming at me at the time I went around him.
Were there any other factors that came into play?
No.
Okay. How fast were you going when you passed those two vehicles?
I was going faster than the people in front of me. I just don't know how fast.
And what happened after you passed Sheriff Sanders' car?
I pulled over to the side of the road to meet it. Well,
Why did you pull over to the side of the road?
because I saw his lights on.
No further questions, Your Honor.
Ms. Kitmacher.
Yes, Your Honor.
You may cross-examine.
Thank you.
Cop has video. I don't know what the video shows.
Morning.
Morning.
You agreed that you were speeding, right?
I was going above the speed.
You agree that you passed more than one vehicle while driving in the oncoming lane of traffic?
While I was behind Sheriff Sanders, I was also behind another person behind him. Yes.
So you passed more than one vehicle in the oncoming lane of traffic? You would agree there was another car that you could see in the oncoming lane when you made that pass?
It was not there at the time I went across the line.
At the time you passed the vehicle behind Sheriff Sanders' car, you could see the vehicle coming at you?
No.
You agree that there weren't any bends in the road? The weather was clear?
Yes, it was.
The other car had to pull to the side of the road to avoid you?
The other car pulled over to the side of the road because he saw flashing lights.
You agree that
Boom.
speed limits exist for a reason?
Yes.
And you agree that it can be dangerous to go into the oncoming lane of traffic?
Objection. Relevance.
Overruled. And could you repeat your answer, please?
Correct.
You agree it can be dangerous to pass multiple vehicles at once?
Yes.
And you would agree that you cut it too close in passing
I
the
would
two
not.
vehicles? You would not? No further questions.
Redirect there, Mr. Shashevsky.
She has to call
No redirect,
rebuttal.
Your Honor.
She has to call rebuttal here.
And ma'am, you can go back to council table and join
Okay, so now there is testimony that there was someone in her car. So now
your counsel.
if they
Any
tried to do
further
a
witnesses,
JOA,
Mr. Shashevsky?
No, Your Honor, at this
Both
time,
charges.
defense would rest its case.
Any rebuttal testimony
Yes.
at this time, Ms. Kitmacher?
No, Your
no.
So members of the jury, we're going to take you
What?
workout, walking in and out of the jury room. I'm
She's
send
gonna
you
walk.
back there again one more time. This break is going to be a little bit longer. And then when you're brought back into the courtroom, you'll hear instructions on the law and argument from counsel. Okay, so you're going to go back there, and I'm not going to predict how long the break's going to be. I'm notoriously bad at that. So when we're ready, we'll call you back into session.
Wow. I'm surprised they didn't call some rebuttal testimony to basically say, no, she was lying. She passed 3 cars or 5 cars or something else. Prosecution, that was an opportunity. You retained him for a reason.
Yes, of course.
Thank you.
Yep. And so So council needs to approach, we need to go through these jury instructions because a lot of them, some of them are going to be read.
6 jurors, 6 jurors, 1 alternate, I think is what they have. Maybe just 6 jurors. I don't know. There was dash cam video. We didn't get to see it, unfortunately, Tash. And maybe the dash cam video securely just supports the
introduction was maybe good.
The prosecution, but it also might not really be clear, or it might not.
Duty to discuss, yes. Plead not guilty, yes. Evidence has to be expressed and circumstantial, yes. We're going to pull this one because she did testify. And we're going to pull this one because there's not a separate crime. There's just a single crime now. Crime of reckless driving will be.
I think that is her son.
Yes. Willful and wanton, yes. Intent and intention, yes. Automobile is a vehicle, yes. Reckless endangerment.
Obviously.
We'll pull this one out. And then we'll do the to convict on that. And then this reckless, do we leave this one in or no?
No, that one would be, this is one, I think this is 10.03 that I
Okay.
flagged.
And then you have reckless and willful and wanton in there also.
If this is 10.03.
Yeah, that's what that one.
This is one that I flagged that you're not
Less-
supposed to use in a driving charge.
Okay.
It's not my concern
Then we'll
about.
take
Less than an hour of
physical injury,
testimony.
we don't do that. And then when you begin delivery.
Only thing about that is that it does say each crime, like the introduction instructions in this, in a couple parts says.
Okay,
each
that's fine. I
crime.
can, with that, I can just make,
Could we change that?
what's that?
Could we change that to?
Yeah, can you get that printed?
They should have. Prosecution should have
Yeah.
called the
Can you
second
change it in
officer
print? Why don't you can change that
Yes,
in
I
print?
don't know that I have.
to
access
establish the other person in
this
the vehicle.
printer.
I think Janice says.
Janice, sorry.
Okay.
And you're really, because we'll get a copy of this.
Yep.
Thanks.
Yep.
I know sometimes Thurston County has some pretty stiff penalties for crimes that other jurisdictions might just, $120 payable in 30 days. Josh, while you're doing your research, do you happen to have the penalty, the maximum penalty on just reckless driving? Endangerment's been thrown out now. Denise she's just here for the verdict music. I've got it queued up. We're ready. The volume's up and everything. It's going to take all of 3 seconds to summarize this case. Make sure the verdict is unanimous. That's the most important instruction for Thurston County. Okay, maximum sentence. Thank you, Josh, for this. Maximum sentence, a year in jail and a $5,000 fine, as well as a 30-day license suspension. I think the 30-day license suspension is mandatory. And then the fine and the
I'm not
jail
seeing
time.
it in the first. I thought it was, but it might just be in the closing instructions.
No, in the closing instruction, I don't see it. I
You
don't see it in the closing instruction either.
Okay, I'm not seeing it in the first one. I thought that there was.
No.
So if you want to
Oh, I
start
apologize.
with that, otherwise,
Yeah.
yeah.
Why don't you read that last instruction?
The last instruction.
Yeah.
Okay.
So I think we can send it as is.
Thank you. One moment.
Peter, you got
I know there were several places that said of each crime.
your
But
Z06.
I appreciate you raising that, Council. I'd really do.
So can you go off the record again?
Okay, it's
What's
the
it?
What'd you say? Okay.
it's instruction 4.01, the plea of not guilty, and it says that plea puts an issue.
Okay. What number is it on the?
I don't know what number it is on.
Would have been one of the beginning ones, right?
Yeah, it's the defendant has entered a plea of not guilty that puts in
Number 3, probably.
issue every element of
That's number
each
3.
crime charge.
Any objection to me just whiting out each and then handwriting in the?
No objection.
I don't want to
White out.
reprint
Janice, did
this.
you give that to me yesterday?
Get me the white out.
Where is it?
That's funny.
And I see that a couple times in the
Laura
first
Lee,
paragraph.
thank you. Thanks for coming over. I appreciate it. And yeah, there's some amazing creators in LawTube and LawTube adjacency world where I live in LawTube adjacency. Melanie
The
Little,
only other thing
obviously,
is in the
Just a minute.
more on the legal side. I'm not a lawyer, but I think we've been on.
And what's the other one?
in the closing
2.
instruction, it says you must fill in the blank provided in each verdict form.
Which I think
And
other
where's
times I've
that?
been
I
on
thought
with
it just
Melanie.
said both of them.
The second paragraph from the bottom.
Anyway, appreciate
That
the
instruction.
kind
In
words.
the verdict form.
I love that there's so many different people that cover court cases, and you get
Thank you.
so many different viewpoints and everything. It's great. This is the best part of the internet. It really is.
Okay, so Janice, I have terrible news. So we pulled a bunch of forms out. So rather than go through each one, we made how many? 1, 2, 3, 10 copies of that.
You need to white out each one.
Perfect.
What's that? Now you're making fun. Now you're mad at me. I don't like it when you're mad at me. You know this.
Quit being mad at me. Dang it. Janice is like, you told me to make 10 copies, and now you're changing it. Yeah, I think they're just joking. I think that was not an actual like disagreement between the two. This court is so laid back. I have a hard time imagining the judge or the magistrate in this case ever being mad at anybody. To everyone who's coming over from Melanie Little, thank you so much. Appreciate her giving us a shout out. She does great work. Love that the community is supportive like that. You guys are amazing. Thank you and welcome. Good to have you here. We are a little bit away from 70,000. Let me see if I can check. Or 67,000, excuse me. We're right where we always are. We're at 66,953 subscribers. That's where we are. 66,953. So we're up about 6 on the day. 10 minutes for closings. I don't think if we would need that. We can probably split it between the two sides. This is really just a... I think as far as prosecution goes, what they need to do is say, look, jury, you saw it on tape. You saw it with your own eyes. You saw this wasn't safe. And the jury probably can tell from the video if it looks like the car's like swerving off the road and trying to avoid the oncoming traffic, or if it looks like they're like, oh, there's a police officer ahead. I need to pull over. See, I can display the number, but it just requires me to change this little setup here just briefly. I have to take this off. And this on. Take it to that monitor. Embiggen. And turn that up. That's the wrong one. That would be nice. This is my logo. Let me switch that so it's doing a different downstream keyer. Oh no, not downstream keyer. We want super source. That's what I was doing wrong. There we go. Hey, none of that. Who said that? Sharkey. All right. I can make it bigger and everything, but it's currently formatted for the count for the other trial we're in, which is on 53 for the record, 53 objections. I may or may not have been racing my brother's brand new Camaro. Shiny cars go fast. The sheriff could have given a verbal warning. I've had a couple in my day. I doubt that in this this roadside exchange that she was all mouthy and challenging him and everything else. I doubt that she was that person, right? Usually officers use a little discretion. Sometimes they'll pull over like a speeding motorcycle, going way too fast, but it was in an area that was like no one else was around, and they're like, look, I understand, I ride bikes too. You really need to slow it down. And they're like, yeah, I stopped. As soon as I saw the lights, I knew I'd made a mistake, pulled over. The cops are like, hey, I appreciate you stopping. Okay. So I didn't have to try to chase you. Just keep it under the limit next time. And they say, okay. And they walk away. I think it could have been one of those in this case, but possibly the sheriff making the stop, then calling a deputy to say, hey, take this for me. Of course, the deputy's going to be like, oh, if the sheriff stopped him, I'm writing a ticket, right? I'm not going to be like, yeah, I gave him a warning, boss. So it's sort of like sealed her fate at that point. I mean, if the boss thought it was important to interrupt his drive home after hitting the gym to effectuate a traffic stop in shorts and gym shoes, of course the deputy's going to follow through and arrest the driver and tow the car, right? So, yeah. It seems like a little much, right? The arrest was a little much. Can do a poll on this one. I don't know. I think the jury's just going to look at each other and all nod and be like, Judge, we're ready. We just need to fill out the form. Reverend Beasy, I saw it. I just didn't click on it. Some of them I choose not to highlight. This little court has been a fun one over the years. We've had some really interesting trials happen right here on this little Zoom court in the Holiday Inn of Thurston County, Washington. No, just kidding. It's actually in the courthouse. It's in a converted meeting room or something. They started using this during the days of COVID, and over time, the chairs you see in back, those are the jury selection chairs. That's where the jury's selected from. Often we see the jury get selected, and it's fun to sit in and listen to that too. But they're slow to change. They've been using it, and it works, and so here we are. And so the chairs are still spaced apart, not quite as far as they used to be, but we had Mr. Frog here, yes, which one day we might get him back. We might see a conclusion to the case. He literally got up and left at lunchtime in the middle of his trial and never returned. And they're just like, whatever. Thurston County's like, just pretend it didn't happen. Just file it. Sure, put a warrant out for him, and just, if you see him, if he's not actively hurting somebody, just keep driving because it's not worth our time. They got approval to build a new courthouse. They used this video as evidence of why they needed one. Maybe the new courthouse will have just fantastic audio and we'll be able to see the exhibits. That would be great. Just watching the evidence, digital evidence, that would add so much to this court. Hopefully the new courthouse isn't super expensive and law enforcement feels compelled to write extra tickets to justify the expense. Mel, how much do you charge and when can you get here? I'm just asking for a friend. Super hot from scrubbing floors.
They were admitted.
Let's see. Could have given warning, not legally required. That's true. They have discretion. Just, Troy, don't speed, and whatever you do, don't drive over the gore point. Don't cut across the gore point. That'll get you every time up there. Tisha, you missed less than an hour of testimony, which was basically the whole trial. Officer pulled. I can summarize it. You're going to hear it in verdict music as well. But this woman in the left, who's been described as wearing a pink top, it doesn't look that way on my screen, but possibly in real life it looks more pink. Maybe without the, nope, still not pink. She was driving on a road, Thurston County, and passed a number of vehicles, at least two. The front one was the sheriff, the elected sheriff, Sheriff Sanders from Thurston County. He was coming home from the gym on his day off. Well, he had to go into work anyway, but he went to the gym and was coming home on his day off. He's wearing gym shorts, gym clothes. As soon as she passes him, and he notices her coming up in the rear view mirror on the driver's side as he's peering.
And did she get one? Did all three of them get one?
Oh, yep.
He flips on his lights and pulls her over.
Thank you.
Reckless driving, reckless endangerment.
Ready to bring them back in?
The reckless endangerment charge was dropped on a directed
If we're
verdict.
jumping straight to closing, could we have a minute between?
Okay.
I know we don't want to wait a crazy.
That's all right. I'll come back. I'm going to go upstairs. I'll come back at 10:15.
Thank you, Your Honor.
You have 3 minutes. It's 10:12. It's 1:12 right now. They're on West Coast, so we've got 3 minutes. You have teens they can scrub.
I think it's just from his training, like Sheriff Sanders is used to like talking to the jury, which is good, but it was just like a weird angle.
Yeah. I think I just kidding. Let's see. Make sure.
That looks good. It's a good spot. We can see well. We can hear well. Just don't walk around while you're talking. Okay, judge is just walking upstairs and walking back down. It is 13 minutes after the hour. He has 2 minutes to get back down here. Tomorrow is my 22-year anniversary. Congratulations, Reverend Beasy. 22. I always like it when the anniversary year corresponds with a common caliber of firearms. And 22 is a small one. But it does, in fact, line up. You've got like 22, 38, 40, 44, 45. 50. And then you get in the big ones like 454. That's a long one. 380. I guess you could technically get to the 30-06 as well, which is just a little over 30. I kill me. Oh wow. How about 55? I can't think of anything that's a 55 caliber, not a common one at least. Where is the sign-up link for birthday? We'll have one of the mods put it in chat here in just a second if we have one here, which I think we do. Josh is here. Josh, can you put the birthday command up? We'll get you added to the list. Okay. It's now time, Judge. You should be back. It's 15 minutes after the hour. This is the Continental Courtroom, the only courtroom where free breakfast and Wi-Fi are included in your court costs. That's funny. Like jury, if you want to head over to the breakfast bar, we'll be serving breakfast until 10.
In front of the Walmart.
There's the birthday form. You can add your name to the birthday form at any time. We will save it. So if your birthday's in a month, you can add it today. Just add it for the day it is. Just checking to make sure we're okay on time. Oh, we restarted, so we are okay. Do you think we'd have time to go to lunch on this one, on the verdict watch? Don't think we can. Oh, we'll get to use the first ever. For the first time ever, the Trial TV's clock for us. Trial TV made a verdict watch clock for us. Let me get that pulled up. Okay.
Happy birthday. You look good.
To update the logo. Just 1 second. Channel. See if this works. Okay, let me get rid of the counter. Don't need that anymore. Let me show you our counter here really quickly. Our verdict watch clock, which is quite impressive. Okay, you ready for this? This is it. Boom. Is that awesome? It's crazy. We'll show you how it works in a minute.
So a lot of the numbers are going to be, there's going to be some missing numbers basically. And go ahead and bring them in. You can be seated in the courtroom. So when you came back in, I see you all picked up, there was a packet labeled court's instructions to the jury. I'm going to read those to you in just a few moments. You know, and I've learned over the years that different people have different learning and listening styles. Sometimes most people follow along as I read. Some people just sit and listen. Whatever your particular learning and listening style is fine with me. One other thing that I do want to tell you that you were told earlier that there are 2 charges. Only 1 charge is going to the jury, and that's the charge of reckless driving. As a result of that, it's going to be an interesting number system. You'll see. There's going to be some gaps in the numbers. Don't worry about that. But the law that will apply in this case is as follows. Instruction number 1. It is your duty to decide the facts in this case based on the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way, decide the case. Keep in mind that a charge is only an accusation. The filing of the charge is not evidence the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence you're considered during your deliberation consists of the testimony that you've heard from witnesses, stipulations, and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence, and the exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching a verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party has introduced it. You are the sole judges of the credibility of each witness. You're also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness testimony, you may consider these things: the opportunity of the witness to observe or know the things that he or she testifies about, the ability of the witness to observe accurately, the quality of the witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you, and you must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on the lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. And I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions, and during your deliberation, you must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially and with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and change your opinion based on further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charge. The state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt, and the defendant has no burden of proving that a reasonable doubt exists. The defendant is presumed innocent, and this presumption continues throughout the entire trial unless, during your deliberations, you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If, from such consideration, you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 4. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case, and one is not necessarily more or less valuable than the other. Instruction number 7. A person commits the crime of reckless driving when he or she drives in a vehicle in a willful or wanton disregard for the safety of persons or property. Instruction number 8. To convict the defendant of reckless driving, each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about March 14, 2025, the defendant drove a vehicle. 2, that the defendant drove the vehicle in a willful or wanton disregard for the safety of persons or property. And 3, that this act occurred in the state of Washington, county of Thurston. If you find from the evidence that each of these elements have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, If after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it would be your duty to return a verdict of not guilty. Instruction number 3. Willful means acting intentionally and purposefully, and not accidentally or inadvertently. Wanton means acting intentionally in heedless disregard of the consequences and under such surrounding circumstances and conditions that a reasonable person would know or have reason to know that such conduct would, in a high degree of probability, harm a person or property. Instruction number 10. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 11. An automobile is a vehicle. Instruction number 16. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during trial if you wish. You have been allowed to take notes to assist you in remembering clearly, but not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly, and for this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question, give it to, it says bailiff, but in our case, clerk. I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted in evidence, these instructions, and verdict form for recording your verdict. Some exhibits and visual aids that may have been used in court, but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in the verdict form the words not guilty or the word guilty according to the decision that you reach. And because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision, and the presiding juror must sign the verdict form, notify the clerk. Clerk will bring you into the court to declare your verdict. Members of the jury, those are the instructions or the law that will apply in this case. Would you now give your attention to Ms. Kittmacher for her closing argument on behalf of the state? Ms. Kittmacher?
Yeah. Your Honor, would it be possible to have a sidebar?
Yes.
Your Honor.
Same rule applies at sidebar. Don't try to listen to what we're doing over here.
Yes.
What if you talk into the mic? Are they going to drop the charge? Your Honor, I just can't do this anymore. I wrote my closing with the 2 charges in it. I don't know how to change it.
Now, give your attention to Ms. Kittmacher for her closing argument on behalf of the state. Ms. Kittmacher?
Thank you, Your Honor.
Here we go.
Thank you for your patience. On March 14th, 2025, in Thurston County, Washington, Ms. Fogelman drove in willful or wanton disregard for the safety of persons or property. I know you've heard a lot of information today. You heard stuff yesterday, excuse me. But I want to remind you that you're here to determine if Ms. Fogelman is guilty of reckless driving. The state has met its burden, I submit to you, beyond a reasonable doubt. It's the state's duty to prove beyond a reasonable doubt that a crime has been committed. You heard from the judge, and it's in your jury instructions, that a reasonable doubt is one for which a reason exists. It may arise from the evidence or lack of evidence. It's such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence or lack of evidence. And if from such consideration, you have an abiding belief in the truth of the charge, then you're satisfied beyond a reasonable doubt. You also heard the definition of willful or wanton. Willful means acting intentionally and purposefully, not accidentally or inadvertently. Wanton means acting intentionally in heedless disregard of the consequences and under such circumstances, such surrounding circumstances and conditions that a reasonable person would know or have reason to know that such conduct would, in a high degree of probability, harm a person or property. I would submit to you that if you believe Ms. Fogelman conducted a double pass on a 2-lane road and cut it too close, merging back in front of the car coming from the oncoming lane, if you believe that the other car had to slam on their brakes and move to the side to avoid her, that she had to quickly get back over into her lane because there wasn't much space between the two cars, if you believe any of these things, I submit to you, you are convinced beyond a reasonable doubt that she is guilty of reckless driving. And if that's the case, you have a duty to return verdict of guilty. Now, to your 2 convict instructions, tell you that to convict Ms. Fogelman of reckless driving, there are 3 elements that have to be proved beyond a reasonable doubt. Okay. Number 1, that on or about March 14th, 2025, the defendant drove a vehicle. Number 2, that the defendant drove the vehicle in willful or wanton disregard for the safety of persons or property. And number 3, that this act occurred in the state of Washington, county of Thurston.
So 2 are gimmies. It's just the middle one.
It's undisputed that the defendant drove a vehicle on March 14th, 2025. You saw the dash cam footage showing the car driving. You saw the time and date stamp on that footage. You heard Sheriff Sanders tell you the date that it happened, or confirm the date that it happened. He described how he identified the driver, that he confirmed it was Ms. Fogelman. It's also undisputed this happened in Thurston County, Washington. Again, you heard Sheriff Sanders describe the location. What's really contested today is that second element. The defendant drove the vehicle in willful or wanton disregard for the safety of persons or property. Now, in his opening statement, defense counsel told you to look for what was missing in this case. He implored you to think of this as a traffic infraction, incorrectly charged as a criminal offense. He asked Sheriff Sanders about the oncoming driver pulling over, suggesting that that was in response to Sheriff Sanders' lights rather than Ms. Fogelman's vehicle. But you heard Sheriff Sanders say that he that he saw the vehicle pull over and slam on their brakes almost as soon as they saw the defendant's car coming. Now, the jury instructions tell you to use your common sense and experience when considering evidence. I submit to you, think of your own experience both as a driver of a vehicle and as a passenger in a vehicle and an observer of other vehicles. We talked in voir dire about when you think it's okay to pass other vehicles, what you look for before you do that, when you wouldn't pass. I submit to you, consider that experience, and also take a close look at the video that will go back to you, back with you to the deliberation room. Take a look at when Sheriff Sanders' lights come on in comparison to the other driver pulling over. I submit to you that this was not a botched traffic investigation, as defense counsel suggested, and I believe will likely suggest in closing. I submit to you this is a case where the defendant was speeding, admitted to going above the speed limit, passed multiple vehicles at a time on a busy street, cut it too close to the car coming in the oncoming lane, and in doing so forced that vehicle to slam on their brakes and move to the side of the road to avoid the defendant. Again, follow the instructions, use your common sense and experience, and consider the evidence that you do have. The state has met its burden beyond a reasonable doubt that Ms. Fogelman was driving in willful or wanton disregard for the safety of persons or property on March 14th, 2025 in Thurston County, Washington, and ask that you return a verdict of guilty. Thank you.
5 minutes on the button.
Ms. Kittmacher, members of the jury, would you please give your attention to Mr. Tashevsky for his closing argument on behalf of Ms. Fogelman. Mr. Tashevsky.
Thank you, Your Honor.
See how long defense needs to knock some
I would
holes
like to start by highlighting a particular instruction. It's an instruction that I think is perhaps one of the most important in the packet that you have, and that is instruction number 2. And it's the last couple sentences of instruction number 2. During your deliberations, You should not hesitate to re-examine your own views and to change your own opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinion of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. Now, in our criminal justice system, you as members of the jury are empowered collectively. You're empowered as a group. But as instruction number 2 highlights, you're also empowered as individuals. Any single one of you has the power to raise your hand and say, no, the state has not met its burden. I do not agree that a verdict should come back guilty. And that's why I think it's particularly important to highlight number 2. Now, we are not here today because Ms. Fogelman has been assigned a traffic citation for improper lane change. That's not why we're here today. We're not here because of a traffic citation, a traffic ticket for failure to yield. We're not here because of a traffic citation for wheels off the roadway. We are here because the state has accused Ms. Fogelman of having committed a criminal offense. And when that happens, when someone is accused of having committed a criminal offense, the state, the government, is bound by significant burdens. And I want to highlight a couple of those in the instructions. The first is number 3, instruction number 3. And I'm going to highlight the third paragraph. This speaks to the requirement that the state prove its case beyond a reasonable doubt. This isn't a civil negligence case. This isn't a traffic infraction. This is a criminal charge, a criminal allegation. And paragraph 3 says, a reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from, and so the first part of paragraph 3 speaks to what is a reasonable doubt. And if you find a reasonable doubt, you have to return a verdict of not guilty. The other significant burden that the state has in this case is detailed in instruction number 9. And instruction number 9 provides the definition of what reckless driving is. Reckless driving is willful or wanton. Willful means acting intentionally and purposely and not accidentally or inadvertently. Wanton means acting intentionally in heedless disregard of the consequences and under such surrounding circumstances and conditions that a reasonable person would have known or have reason to know that such conduct would, and here's really key language, in a high degree of probability harm a person or property. So there's 2 significant burdens. There's a high culpability requirement. Again, this isn't a traffic ticket. This isn't a civil negligence case. This is someone being accused of a criminal offense. They have to, specifically reckless driving, they have to prove this high level of culpability, willful or wanton. And they have to prove it beyond a reasonable doubt. Now, in terms of the evidence has shown some things and not shown other things. And I'd kind of like to walk through both of those. The evidence has shown that at the portion of the roadway where Ms. Fogelman passed the 2 vehicles, the northbound lane and the southbound lane were separated by a dashed yellow lines. You heard Sheriff Sanders testify that that means that's a passing zone, that if it's safe to do so, somebody can pass in those circumstances. That portion of the roadway was not separated by a solid yellow line. A solid yellow line would have mean you cannot pass under any circumstances. That was not the condition at issue here. Regarding the weather conditions, the conditions of the roadway, and you heard both my client, Ms. Fogelman, testify to this, as well as Sheriff Sanders. This took place at roughly 2:30 in the afternoon. It wasn't raining. The road was not wet. Because it was the afternoon and it wasn't raining, the visibility conditions were fair. Ms. Fogelman had a good view of the road when she went to effectuate this pass. The portion of the roadway where Miss Fogelman passed these other two vehicles was a straightaway. There wasn't a bend or a turn in the road that would have limited her visibility in terms of what was up ahead. Now, soon after, in terms of what else was shown in the testimony, soon after Miss Fogelman passed the sheriff, he activated his lights and effectuated a traffic stop. And I believe you heard both Miss Fogelman testify and Sheriff Sanders testify that that was almost immediately. That was fairly quickly after she passed that he activated his lights. A car in the northbound lane, and this video will go back, and I encourage you, as Ms. Kittmacher encouraged you, to review that video and take a look at it. A car in the northbound lane appears to possibly slow down and drive kind of on the rightmost side of their lane. But I want to highlight that you heard Sheriff Sanders say several important things. First, you heard him say that it is fairly common that when law enforcement effectuates a traffic stop and has their lights on, other motorists will frequently give deference out of safety for the law enforcement officer and the other party involved and try to, as best they're able to, kind of give them space in the roadway and avoid the roadway. So it's important that his lights were activated almost immediately. I'd also highlight in terms of what was shown that as Sheriff Sanders testified, that at the point at which Ms. Fogelman passed, that car in the northbound lane was, I believe the exact words were, a few hundred feet down the roadway. Not 4 car lengths, not 5 car lengths, not 40 feet, not 50 feet, a few hundred feet down the roadway. I would also ask that as you look at that video, at the moment that Ms. Fogelman fully re-enters her lane of travel, again, it's that few hundred feet, and also it's about 3 seconds or so pass before passing that vehicle in the other lane, in the northbound lane. Some aspects to Sheriff Sanders' testimony that I would like to just highlight for you. I believe Sheriff Sanders testified that the northbound lane, the car in the northbound lane, drove off into the shoulder. I'd ask that when you take that video back and you review it in the jury room, to see if that's accurate, to see if that car actually drove off into the shoulder. I would also highlight that Sheriff Sanders testified that Ms. Fogelman was speeding, but that there was no radar detection. It was an estimate. And Ms. Fogelman actually even acknowledged, yes, I was going faster than the cars in front of me to get past them and re-enter my lane of travel. And just noting that there was not a radar detection of speed in this case. I'd also highlight that Sheriff Sanders stated that even once he became aware that Ms. Fogelman was passing him, he did not slow down. And just highlighting that fact for you. In terms of things you did not hear, things that were not shown to you, we did not hear from Deputy Zachary Stevenson. You heard Sheriff Sanders testify that his interaction with Ms. Fogelman was brief, a matter of moments, and that's because he wasn't in patrol clothes, or at least I believe that's what he testified. That was a reason that he made it super brief, a matter of minutes. But that he wasn't sure how long Deputy Zachary Stevenson interacted with Ms. Fogelman, but it was longer than his interaction with my client. And we didn't hear from Deputy Stevenson to get his perspective on any of those conversations or anything that he might have had to say. We didn't hear from the other driver in the northbound lane. And additionally, from Deputy Sheriff Sanders' perspective, they couldn't see the brake lights of that other vehicle. And I kind of highlight the fact that we didn't hear from some of these people because it connects to the burden, but the burden's on the state. The defense does not have a burden to produce a case to prove they're innocent. My client is innocent unless there's proof beyond a reasonable doubt. There were things that we didn't see in that video, and you'll see as you review it. There were no pedestrians on the shoulder of the roadway. There were no pedestrians crossing the roadway. There were no other cars waiting at cross streets during the period at which the passing was effectuated. Nobody was checking their mail at the end of the driveway. You've heard no evidence or testimony of intoxication. There's been no evidence that drugs or alcohol played a role here. I'm kind of going down a list of things that might potentially indicate reckless driving that we don't have in this case. Ms. Fogelman did not race another vehicle. There's been no evidence or testimony that she was racing another car on the roadway. There's no evidence that Ms. Fogelman was on her phone or that she was distracted when she effectuated this move. There's no evidence that she fell asleep or that she was tired or had any other thing going on that would have made her not be a competent driver in that moment. There was no car accident. She never left the portion of the roadway designated for vehicular travel. That's kind of lawyer speak for saying, you know, she didn't drive half off the road or half on the road or anything like that. She stayed within her lane of travel. She did not run a stoplight. She did not blast through a stop sign. She did not speed through a construction zone. She did not speed through a school zone. She did not blast past a school bus that had its lights activated, dropping off kids. These are all stuff that we did not see in this case that might, in some other case, indicate reckless driving, but we don't have it here. In conclusion, I'd like to make a couple points. I'd first like to thank you. I genuinely mean this, that anytime I have an opportunity to address a jury, I consider it a privilege and frankly an honor. It's an important part of our system that anytime someone is accused of a criminal offense, that we have a right to go to the community and have them determine whether the state has met its burden beyond a reasonable doubt. And so I thank you for your attention throughout this case. I also want to say that my comments here in closing as the attorney for Ms. Fogelman should not be seen as a critique of the sheriff's department as a whole, should not be seen as a critique of the leadership of the sheriff's department. That's not relevant, and none of my comments should be interpreted in that manner. What my comments should reflect is that in this specific case, the facts of the case do not meet the definition of the crime that is alleged. And I want to briefly return to instruction number 9. And this is the definition of reckless driving: willful or wanton. Willful means acting intentionally. Well, you heard Ms. Fogelman testify that she did not intentionally disregard a known risk, that she waited until it was a passing zone, that the car in the northbound lane was so far away, again, at least a few hundred feet, that she did not believe in that circumstance it posed a risk. Wanton means acting intentionally in heedless disregard, and key language, in a high degree of probability. And under these conditions, a passing zone, afternoon, not raining, it's not wet, there's no pedestrians, there's good visibility, there's no evidence that there was a high degree of probability that some sort of accident would have taken place, and therefore these definitions are not met. This case is a story of a traffic infraction, a potential traffic infraction, treated as a criminal offense. The state has not met its burden of proving this case beyond a reasonable doubt, and therefore both the facts and the law require that you return a not guilty verdict. Thank you again for your time and your attention. I really do appreciate it. Thank you.
Thank you, Mr. Kuczewski. And members of the jury, the state carries a burden of proof in these cases, and as such, they're entitled to a rebuttal argument. So for one last time, would you please give your attention to Ms. Kittmacher for her rebuttal? Ms. Kittmacher?
Yeah.
So I know I already read this to you, but I want to read it to you again. Your jury instructions tell you that a reasonable doubt, a reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It's such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Now, the abiding belief part, I would submit to you if you are convinced today, tomorrow, next week, that the defendant was speeding, passing multiple vehicles in the oncoming lane of traffic as a car was coming directly towards her from the opposite direction, that the oncoming vehicle had to take evasive maneuvers to avoid her, then you have an abiding belief in the truth of the charge, meaning in this case, the defendant is guilty of reckless driving. I would submit to you, follow the jury instructions, use your common sense and experience, consider what evidence you have, watch both parts of the video again. And remember that reckless driving means driving a vehicle in willful or wanton disregard for the safety of persons or property. That willful means acting intentionally and purposefully, not accidentally or inadvertently. Wanton means acting intentionally in heedless disregard of the consequences and under such surrounding circumstances and conditions that a reasonable person would know or have reason to know that conduct would, in a high degree of probability, harm a person or property. I would also highlight to you, defense counsel again argued to you that there are a lot of things that you didn't hear. You didn't hear that she was intoxicated. You didn't hear that she ran a red light. You didn't hear that she went off the road, and so on. He also told you that you didn't hear from the second deputy who arrived, the deputy who responded after Sheriff Sanders. I would submit to you, you did not need to hear from him. You have the video itself of the defendant's driving. Rewatch it. I would also submit to you that just because alcohol wasn't a factor, that racing wasn't a factor, that those things that defense highlighted were not factors, doesn't mean that the definition of reckless driving wasn't met. I would submit to you, review your jury instructions that are the law.
Submitting here.
You won't see a list of factors like that in there. I would submit to you that speeding, passing multiple vehicles in the oncoming lane of traffic, as a car was driving directly towards her from the opposite direction, that the oncoming vehicle having to take evasive maneuvers, that is enough. The state has met its burden beyond a reasonable doubt. And Ms. Fogelman was driving in willful or wanton disregard for the safety of persons or property on March 14th, 2025 in Thurston County, Washington. Again, review your jury instructions, look for what is required and what is not. The state asks that you return a verdict of guilty of reckless driving. Thank you.
Thank you, Ms. Kitmacher. And now, members of the jury, the 1 through 6 of you are going to be taken back into the jury room. You'll begin your deliberations. Juror number 7, I'm going to have you wait in court for a few minutes. If you have things back there, you can get them and then you're free to go. My instructions still remain, though, because I think I said at the outset, I've had the experience where deliberations have started and someone's had to leave, and then someone has to be called back in and deliberations start all over again. But leave your contact information with the clerk, Janice, and then she will contact you when a verdict has been reached, one way or the other. All right?
All right.
You have her, you know, what's her phone? What do you do? Check you out.
All right. So
Yeah.
we're going to.
What? Yeah.
We're going to start our verdict clock here as soon as the door shuts.
Juror number 7's the alternate. All right. That's all right.
Here we go.
Having trouble between jury instructions, unless we're having a little trouble with numbers today. But I think I said at the beginning, juror number 7, you were the alternate. Yeah.
And Janice, I have this. I'll put it.
I think they're still there.
Go ahead and take them back there. And then give her her phone. Keep the rest of the phones. Take her back. Bring that to me, and then you'll take that back in a minute. Or I could take that now. I just want to mark that as admitted.
Come on, Janice, you got this. You can do this. All right, let's start it now. There's our verdict clock has begun. The thing I like about this verdict clock is I can make it look the way I want. Like I can make it pickle green because pickles are good. Hang on a second. Let's make it pickle green. There we go. Now it's big.
Take somebody else's phone. Okay.
Whose phone do you have? No, I can't get this size.
Thank you for your time, ma'am. We don't see you again. You can get your things out of there and then go if you left them in there.
Take your eggs and go home, ma'am. You're done. You're done. fix this. I can't quite get the zoom right on this.
And then last thing, you take this back there and give that to them. But that's fine, of course. They can. What's that? I can do that. I can. Oh yeah, go ahead. Be within a few minutes.
Did you say we've got a verdict in a few
And
minutes? Just kidding.
actually, so you can go out, people can use the restroom. There's chances these jurors are going to be using restrooms. And if anyone sees a juror go in the restroom, don't go in there with them. Stay outside. And I might want everybody to make a complete effort to stay away from jurors. Do you understand that, ma'am?
Yes.
Okay. Just let me know. I'll be upstairs. Go ahead and take that back. What's that? They should have a way to, don't they have those things back there?
They might need this computer, I think.
Yeah, I think the computer goes back there with them. And if they need to do it, then you can, go back there and take that with them. If they need to see it, they can see it on that computer.
Does it go with them or do they plug it into the TV? Because Teresa told me before that they plug it into the TV.
Yeah, I think there's a way to do it back there.
Yeah.
We haven't.
Teresa did tell me that last time nobody told them how to use the video. And so they said, I think it was our
Teresa.
case. They were like, we didn't watch the video because no one told us how to do it.
I think they were confused about how to use the TV.
I don't think
Is
Teresa
there
works
anything
there
on this
anymore.
computer?
It does have other, I don't think
Oh,
it should go back with
So
them.
go ahead and
I
take
think
it back there. And if they need to see it, to have them let you know, and then we can even bring it back in and show it without comment or instruct them how to use it on the TV. Maybe you can contact Teresa and see how it
Blaine.
works on the TV.
I'll contact Blaine.
Oh, better yet.
Thank you, Janice. I
Don't tell
appreciate
Teresa I
it.
said that.
I think it's important that they be able to.
Yeah, for sure. I just, when I logged into this, I saw other names, which is why I had it unplugged before I put it up there. So
I think Teresa was our clerk that may have given instructions to the jury that were not right in the previous case up here. I think Teresa works somewhere else now.
Haven't decided. Yeah. I don't think, Gabby, I need to even say anything.
The cool thing about this verdict clock that
Be like, what are they?
Trial TV Live made.
Oh, yeah. It's just like, what are 6 people going to decide?
what about you on Instagram? I don't think that
I can add time to it and take away time. I haven't been able to find a verdict clock that would let me do that. So if for some reason the verdict watch goes into day 3 and I accidentally close the window that had the stopwatch on it, or if we have to make a correction to the time because we find out the jury went home an hour before we thought, I can add and subtract time and keep it up to date. So big shout out to Trial TV Live for making this. Chris and Aaron, thank you very much. Apparently we're just going to sit right here. It's going to be a quick one. Finish the sentence. I'm the worst to this, Stevie. My wife would agree with you that I do a terrible job. I get your attention and say something and get you interested, and then my mind goes somewhere else, and my mouth just never finishes what I started with. We are, in fact, on Verdict Watch on one of the gripping major cases in the country this year. Miss Fogelman, Emily Fogelman, has been accused of driving recklessly in Washington County as she passed more than one vehicle and maybe cut it too close. The vehicle in front was the sheriff, not just a sheriff deputy, but it was the sheriff for the county. Sheriff Sanders flipped on his lights, immediately pulled her over, called a deputy. The deputy arrested her, took her to jail, towed her car, and that she has been charged with criminal reckless driving, a criminal offense, not this is not traffic court. This is criminal. She could spend up to a year in jail. Could be charged $5,000 fine and lose her license for 30 days if convicted. So that's a big thing. It's a big thing. Defense attorney did a stellar job on his closing, pointing out that there is really a high bar here, and the elements make you have to be confident beyond a reasonable doubt that she intended and that she willfully disregarded, human life, property. I don't think they proved that. I think that's going to be the sticking point on this one. The originally were 2 charges because she was driving with her son in her car. She testified that she was driving her son home from work at the time that this happened. The charge of reckless endangerment which was charged because her son was in the car, was thrown out on a directed verdict because, as defense properly cited and called out, there was no evidence that anyone else was in the vehicle. The state forgot to ask that question of the witness on the stand, the one witness they called, and they didn't call the second one who could have done it as well. After that judgment of acquittal was granted, then the defendant agrees to testify, and she testified that there was someone in the vehicle. So it's a timing thing, but at the point the request was made, yeah, the evidence was not before the jury, and it was the state was done. They had rested, so it was the right thing to do. So it's always fun to watch a directed verdict or a judgment of acquittal be granted. Good fun. So, looking at the law in Washington, specifically the law about passing on the left does require it to be safe, does require it to be permitted as far as the dotted line in the road. It doesn't specifically state, like in clear and uncertain terms, that you cannot pass two vehicles at once, but it does require you to perform the maneuver without. Let's see, what's the terms it says? It says without, and now it's gone. It basically without, causing any other interaction with other vehicles. And legal minds have interpreted that to mean that that you can't pass a second vehicle. You can only pass one vehicle at a time. That wasn't argued really in this case.
So when Janice comes to it's just the easiest thing. I don't know what the other stuff that I was seeing. I can look at it and see. Put it in like airplane mode, maybe.
Okay. Yeah, it's probably more just intuitive to be able to use the.
Yeah, and I think if I have it open to the, I just wasn't sure.
Prosecution and defense are civil to each other on opposite sides on this one, but I think defense definitely outperformed the prosecution, but I'm not sure if it was sufficient to overcome the presumption of guilt. I know there shouldn't be one, but you've got a video that shows her passing two cars. That looks pretty bad. Apparently, I didn't get to see it. Okay, we are super late for lunch. I don't know what we're gonna do here. How many of you guys ate lunch without me? Probably all of you, because I didn't eat lunch. But how many of you have already had lunch? Every day at 12. I'll be blown away if found guilty. I think the defense closing was quite powerful. Oh, it looks like they're done. We're now waiting for them to come back. They've stopped the live stream. So now we have to do the constant re-clicking game. Or we could jump over to this court. Hang on a second. What is this? Oh, no, we're not. It's mental health court. We're not going to go there. Channel. Let's see, 2, no, 3. Let's see, this court. No, this is all up in Thurston County.
Or actually, we're still good.
This is.
Nope, I'm here. All right. Mr. Sharp.
Thank you, Your Honor. As Ms. Kamari stated, the same situation for all three of these. There are SOCs that are almost done. Each of these, the only issue left is the $60 fee. See if Mr. Dorman's able to pay that this morning, we could go ahead and stand by and dismiss once that's paid. If not, city wouldn't object to giving him some more time. No objection to say up to 90 days. I'll defer defense there on what the plan is today.
No. And Your Honor, Mr. Dorman's request is to see if he can get that portion of the SOC fee waived. There are no affirmative conditions in this case, and he just started working part-time again and supports one other individual. He only makes approximately $1,200 in a month, or anticipates that is what he'll make because he's not yet received a paycheck.
Could the city respond, Your Honor?
Yes.
Thank you. Your Honor, so SOCs are contracts between the parties that the court has ratified. I don't know that's in the court's discretion directly to modify the terms of it. Perhaps the court could consider whether there's been substantial compliance. The city would object to that, though, and point out that this was agreed, 12 months ago. Again, the city's not objecting to extending that if he needs more time to come into compliance with all of the terms, but to modify the agreement at this point, the city believes would be improper.
Okay. Ms. Kamari, I'm inclined to just extend the timing for that payment to be made. The state's mentioned they'd be willing to go as far as 90 days for next hearing. Would Mr. Dorman be okay with doing that? Because I am inclined to just extend this out for that final condition met.
Yes, Your Honor, and we would then request more time to get that paid.
Okay. How much time would you request?
60 days.
I'll defer to Mr. Dorman on that. Up to 90 days, Mr. Dorman.
I was going to say I can do it within the next 30 days. I get paid on the 25th, so.
Okay. Let's be safe here and set it out for 60 days to ensure payment can be made, and we can set a hearing date thereafter to confirm everything's been completed. Does that sound fair? Okay. November 20th at 11 a.m. is the next hearing, Mr. Norman. And have you been getting text messages from the court?
I've been getting emails, but they're few and far between. I cleaned out my email storage space, so I should be getting the emails again. But yeah, I have been.
Awesome.
Okay. We can also send text messages if you'd like to provide a phone number for that.
Oh, yeah.
Okay. Go ahead.
For the phone?
It is 867-5309. 867-5309.
597.
All right. Thank you. All right, Mr. That completes that matter for you. Thank you very much.
Yep.
Let's see
right. And then
I'm going to be watching for
I see Mr. Hutchison on the call, and I just checked the docket entry.
Sorry, I'm going to be watching for this Thurston County Court to come back. But in the meantime, I think we might go over to Judge Middleton, who is live right now. Let's see.
Okay, and then so you drove into Constantine.
Yes, Your Honor.
All right, what were you drinking?
These things called B boxes.
B boxes?
Beat boxes.
Meat boxes.
Yeah.
What's that?
I'm sure people drink those for the taste. What's in it?
Just fruit juice and I think vodka.
Okay. What was your blood alcohol level?
I think a 0.12.
See if I can tell from what I have.
That's accurate, Your Honor. It was a 0.13 PBT and a 0.12 intoxilizer.
All right. Stipulated.
I think I wrote it down somewhere earlier. All right. What do you do, Mr. Whisk?
Like work-wise?
Yeah.
I work at Stryker up in Portage.
I think you told me that before. That's a good job.
Yeah.
This is going to cost your driver's license.
Yeah.
For at least 45 days if you're in a sobriety court. So I'm not sure. We often struggle with young people. They aren't quite ready to make the changes they need to make, but we'll see whether you're even eligible, or we'll discuss it further. We have to set this what's called screening and sentencing. And if you're going to do a sobriety court evaluation, I should take a look. I might set this up. Are you doing anything now? Are you going to see anybody or doing any AA or anything?
I did. I went to a counseling place called Pickles like 2 weeks ago. I'm waiting for her to set me another date to meet with her.
All right.
Mr. George, you're set to be here on Miss Niffen for October 27th.
Yes.
Does that work for you?
Yes, Your Honor.
At 11. All right, Mr. Wisk, I'm interested in learning more about this. Just take this form out to the counter and they'll give you some information about coming back for setting up your appointment with the probation department for the screening and sentencing.
Thank you.
But I'll see you on the 27th of October at 11. Let me see if Vivian's in the background yet. No, she's not. Paul, what have you got for me?
Renee Brasher is, I spoke with her yesterday, so I'm expecting her here today, but she's not here yet.
Okay, that's the only one you have?
That was the only one I have here.
All right, well, she's prone to not always being on time. Luke, you've got Miss Miller and Mr. Dismissed effective equipment. What do you know?
We're prepared on Miss Miller.
All right, well, we take that one.
My wife brought me leftover from dinner, so I have leftovers from the pork roast and some cold baked potatoes, I think. No, they're boiled potatoes.
Good afternoon, Ms. Miller. I may have told you this before. Your lawyer and I both had a friend named Martha Miller.
Oh, yeah?
She was a wonderful person. She was actually sort of more of a friend of Luke's mom and dad, but she passed away. When I see your name, it makes me think of her.
Oh, I'm sorry.
Well, I think of her with fondness. So, well, let's talk about your case.
Okay.
This is an odd case, and we discussed this at the arraignment. You got charged on April 29th with arson of personal property, which was $200 or more, which I believe is your landlord, Connie Swinehart's property.
This is a hot one.
A domestic assault charge upon your spouse, Charity Miller, and arson of personal property over 200, but less than 1,000 is a misdemeanor, punishable by up to a year in jail, and a fine of up to $2,000. Domestic assault is a misdemeanor, punishable by up to 93 days in jail, and a fine of up to $500. We've got two prosecutors here, Angelique Camfield and Abigail Stoll. And so we're lucky in that regard. Mr. Knopfinger, what's our plan here?
Judge, the case is unresolved.
Okay. What's the plea? The case is not resolved, you said?
It is not resolved.
Oh, okay. So we're set for trial?
Yes, please.
Ms. Camfield, what's your understanding here?
Your Honor, the last best offer was to plead guilty to the domestic violence and then to a reduction of the arson to arson of personal property under $200. I've already indicated to Mr. Knopfinger my position on this case. It's not going to get any lower. And I believe that it potentially could have been charged as 2 felony offenses.
I thought so too. When I first read the affidavit, I thought, why isn't this a felony? But you guys know more than I do. Could have burned this whole house down.
Exactly, Your Honor. So I don't know. I may discuss with Ms. Davis a dismissal and amending it, but At this point, it remains these offenses, and I'm ready
There's
to
a
take it to
threat.
trial.
Dismiss and amend. Recharge as felonies. Take the plea. Take the plea.
Miss Miller, do you still live in Goshen?
No, no, my address is 1800.
Sesame Street, Anywhereville, USA.
Charity, is she in Goshen?
Last I heard, she was at Elkhart County Jail.
All right.
She is in custody dealing with some other matters of her own, Your Honor. I have had communication just this morning with Miss Swinehart, however.
Does Miss Miller have an out date?
My understanding is perhaps the 3rd week of October. I haven't been able to check and look into that yet, but that was for Miss Swinehart. I do anticipate the introduction of medical records and a professional from the hospital testifying.
Say that again.
I anticipate that my witness list will include a medical personnel from the hospital where the victims sought medical treatment. And then I also have medical records which have been provided to the defense.
Do you have an arson investigator?
No, Your Honor.
Do you have photographs?
I have requested those from the department. It may be, there should be.
Well, this was authorized in May. We ought to have it by now, but all right.
Correct, Your Honor. Some of the departments don't upload it initially until it's requested by our office, but it is preserved in the system.
Mr. George, do you have witnesses? I mean, Mr. Nossinger?
Judge, yeah, I do have a arrest just a witness, Jennifer Johnson.
We've used all of our dates. November 12th. Because of the holiday for November 11th, we've moved all the pre-exams and prelims and sobriety court to Wednesday, November 12th. So we lost that date. November 26th, Judge Patterson won't be here, so we've lost that date. We have December 10th, which I have attempted to get Rhonda Ives's case set in there with not much success. Tim George, you're on there with Alexander Bryant Kahn. Oh, no, that's Mr. George. I want Mr. Nossinger. So we're looking like we're into next year. So I don't have a date right now. We're going to set this for jury trial. I like witness and exhibit lists within 21 days. If Charity Miller doesn't get out of jail, there may be an issue regarding that, but we should know a better answer as we get into 2026. That means, Mr. George, unless we try your case on November 10th, we'll have gone through the whole year without trying one jury trial. Whoa. But maybe we'll be busier next year now that they got a full staff.
A whole year without a jury trial?
Miller, are you working somewhere?
Yeah.
Where's that?
I work for a lawn service called, I'm drawing a blank right now.
That's a good name.
It's in Elkhart. It's a lawn service over there.
Okay. There's no contact provision that's still in place, no assaultive or threatening behavior, no drugs and no alcohol.
Right.
You're obviously not having any physical contact with Charity Miller, but you can't call her on the phone, text her, email, or any of that until we get this matter resolved.
That's fine.
Have you ever been convicted of domestic violence
No.
charge?
No.
All right, with the prosecutor's consent, you could even be eligible for a domestic violence deferred prosecution, where if you complete the probation, the charge would be taken off your record. The prosecutor has leave. I'll put a 21-day on that to see if we're going to try this. We might as well try it as a felony case. Prosecutor has 21 days leave. Actually, you can do it whether I like it or not, but I'd like to know if we're going to set it for trial or have it set for a prelim to recharge as felony. There are some felony cases that could apply. Felony charges: arson of a dwelling house, preparation to burn, some other things that could be a more serious charge, but they charge that as this. There was also an issue about an automobile. Was there ever any issue of unlawful use of an auto or any of that?
That was not authorized because throughout the investigation, my understanding was that a third party was contacted and there was a trade of the vehicles.
Okay.
I will
Well, I'm not looking
sure
for
that's the case.
All right.
Because if I need to amend it to felony offenses, that certainly would be included if necessary.
We'll set this for trial in 2026. We haven't yet got our calendar put together. I have a trip in January of 2026. I'll have to look at the dates. There's holidays in there that kind of affect things.
Where are we going, Judge?
But where I'm looking, Miss Miller would be a trial date in January of 2026, depending on your lawyer's schedule too. He's got other cases that get set. Anyway, you've made every court appearance. You've stayed in contact with your lawyer. He knows where you are. Apparently you haven't violated any bond conditions. So the matter has continued to be set for a jury trial in January of 2026. And I don't know the date yet, but you're free to go.
I have one question.
Yes.
Right, do I stay in communication with community corrections every week?
Yes.
Okay.
Yes, you do. And you've done that. That's another reason why we want to bring closure to this case. But you do have an absolute right to have a jury trial in this matter.
Yeah.
And all right, you're good to go.
Thank you.
Thank you, Your Honor.
Thank you. Here is Vivian. Tim, what have you got? You're prosecuting? He's gonna go talk to, oh, it's not Vivian, it's Pablo. Well, he's here.
Yeah.
Pablo, thanks for coming on short notice. We've got a pretrial that we need some help on. And then we've actually got a couple.
Good afternoon, Your Honor.
That we need some help on. So I think Vivian got caught in another court. So what I'm going to do, I'm going to put you in a breakout room. This guy's name isn't correct. His name is Jose Lopez Montoya.
Yeah, we didn't know how to change that, Judge.
You're mute, Your Honor.
I'm on mute?
No. Yeah.
I am?
Yep.
Well, how did that happen?
Hello?
Can you hear us, Pablo?
I don't hear you.
Can you hear us? I don't hear you. Best exchange ever.
Oh, hello? Yeah.
His volume was off.
Okay.
Everything looks right on the judge's side.
Can you hear me now?
Yes.
All right. I didn't touch anything. Okay, can you hear me, Luke?
Yes.
All right, I'm going to change his name to the proper name. All right, let me set up the breakdancing room and you guys can talk privately.
Oh, yeah. Send us to that one, Judge.
You should be able to join now.
He said breakdancing, right? Like I can get my moves on.
Ms. Thrasher, would you come up?
Oh.
Welcome, Miss Thrasher. What are you charged with?
All right, this is file number 25448SM, Renee Lynn Thrasher, who I've known for many years as Renee Britton. That's you?
Yes.
And you're here with your lawyer, Mr. Paul Gibson.
Yes.
This is a charge of retail fraud in the second degree, which is a misdemeanor punishable by up to a year in jail. It's a fine of up to $2,000. Prosecutors, again, Prosecutor Stoll and Prosecutor Camfield. Do we have a resolution here?
Yes, Your Honor. It's my understanding that the defendant is going to accept the plea offer. I believe it was a retail fraud, third degree, and we're asking for a no contest plea because of memory. And I did explain that to the prosecuting attorney. And it's my understanding that the prosecuting attorney is willing to make a no jail recommendation.
All right, who's handling this?
I can, Your Honor. That is a correct statement of the agreement, and I am fine with a no contest plea based upon the factual basis that he's provided.
All right, Ms. Thrasher, let's talk about this. They're reducing the charge to a retail fraud in the third degree. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Prosecutor is also recommending no jail. Do you understand?
Yes.
By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. I believe there's an affidavit of probable cause in here, and I can use that for the factual basis. Do you understand?
Yes.
All right. Now, I didn't get an advice of right, so let me take a minute and go through this with you. To understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or a jury.
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson has been appointed to represent you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
And are you going to plead no contest to that charge?
Yes.
This was January 31st, excuse me, December 31st, New Year's Eve. You were at the Walmart store in Three Rivers, and they had apparently seen you doing this before. And you...
In front of the Walmart. In front of the Walmart. In front of the Walmart.
Welcome back from the breakdance room.
Use some double-sided tape and put a UPC code on it, and then stuck that on something at a lower price. Doesn't say how much this was. It was a Sonic the Hedgehog child's toy. And you took the UPC off the toy, put it in your pocket, and then put another UPC on it with double-sided tape. Apparently they had seen you do that before. So that's the charge. It's charged as a second degree because you have a previous conviction for this, but it doesn't appear this toy was of any great value. I'll accept your plea. They're recommending no jail. Did you go to jail when you got picked up on this?
I had a PR bond from here.
Yes. I think you came, there was a warrant and you came into court, as I recall. Is that right?
Yes.
So you didn't actually go to jail. Miss Thrasher, I've known you since you were about 16 or younger. What are you doing now?
I'm going through cancer treatment. So.
All right, so you got some serious health problems. Where are you doing that?
Kalamazoo. For now, they want to send me to Indiana for it.
Are you at the Drake Road one now?
Yeah. For now, they want more aggressive treatments in Indiana.
Well, this is a relatively inexpensive plushie toy. You don't even have a memory of it. I believe you do. You just didn't want to tell me. But does the medication affect your memory?
Yes, I'm on 4 antidepressants also.
If I may, for the court's information, the Sonic toy was $29.84, and then the plushie UPC that she used was $9.97. My understanding is that the toy was left at the store, and she was even refunded $10 that she had paid. Okay. So there was a report later submitted for charging after they received the loss prevention report.
Well, I don't think I have any bond here, but I'm certainly understand. She's struggling as it is. Renee, I'm going to do the standard for this, a $75 fine, $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee. That's $350. It's a lot for someone that doesn't have a lot of money. I'm going to put you on a payment plan for that. All right.
Okay.
I'd like you to pay at least $25 a month. You're barred from Walmart. They probably already did bar you. From me, you're barred from 1 year.
In front of the Walmart.
It's not the.
This isn't something that you needed. It's just a weird
the method
thing that was going on with your self. But you'd done this before, and so they were watching you, and they've got these really high definition video cameras where you can see little receipts and all kinds of stuff. At any rate, right now you got bigger things to worry about than this. But I want you to go out to the counter. Are you still on Connie Drive in Constantine?
Yes.
Okay. You go out to the counter. This matter's over with. I want you to pay at least $25 a month. All right.
Yeah, thank you.
I'm going to stop the live stream for a moment.
Judge is kicking us out. Here we go.
Here's Mr. Stickley.
He gone. He gone. All right. So we have still waiting in Washington for the verdict to come in. Nothing yet. Nothing yet returned. Looking at other courts we can watch while this goes on. Let's see. Judge Middleton just put us on pause. He'll be back in a little bit. Who's this? Who's this guy?
Fentanyl with intent to distribute only count herein a severity level 4 drug felony. Subsequently, the court does adopt the appropriate border box findings as presented this date by argument by counsel for the state and the defense. And the court does grant 18 months probation with community corrections, subject to all standard probation conditions, along with all recommended probation conditions and cost and fees as set forth on page 5 of the pre-sentence investigation report. The court does find that Mr. Ariano is retained. The court finds that an appropriate amount per month to retire the cost and fees herein would be in the sum of $75 per month. Subsequently, the court does advise you, Mr. Ledgerwood, pursuant to KSA 22-3608C, that you shall have 14 days after the judgment of the district court to appeal your sentence. Court advises you, pursuant to KSA 21-4619G, of any expungement right you may have, and the court advises you of your prohibition of possession of any firearm. Immediately after the hearing, there will be a border box for you to go into with Ms. Ashenfelter with community corrections in regards to the specifics of that program.
Is a border box like a breakdancing room?
Any other matters to come before the court? Mr. Sweeney?
No, Your Honor.
And
No, sir.
Mr. Ariano?
No, sir. Thank you, sir.
And Mr. Smith?
No, Your Honor. Thank you.
And Miss Ashenfelter?
No, Your Honor.
There being nothing further to come before the court, court is in recess. Parties are excused. I do need for Mr. Ledgerwood to meet with Miss Ashenfelter in the breakout room box that will be coming up.
We have it here. We'll go in there. Thank you.
Have a good day, everyone.
You too. Thank you, sir.
We'll see you, Judge. It was nice visiting with you. We'll see you. See if there's another case. There is. Sounded like he was leaving, but he's still here. He's leaving. His head disappeared just briefly. Worried me.
And Jim, do you want to take up your case?
Yes, sir. Your Honor, I have 4, and everybody who's here in my office this afternoon. And I happen to have Ms. Joseph here in the office with me.
Thank you.
Today is the 18th.
And court goes on the Zoom record. Case is entitled State of Kansas versus Aspen C. Joseph, 25 CR 81. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Ms. Joseph, appears in person and by court-appointed counsel Jim Watts. Also appearing at this time is Court Service Officer Ryan Smith, and also appearing from Community Corrections is Intensive Supervision Officer Teresa Stanfield. This matter does regularly come back before the court this day for sentencing. In anticipation of sentence, the court has ordered a pre-sentence investigation report. The court has received the same. I trust that counsel for the state and the defendant have received a copy. And before proceeding any further, is there any objection to the criminal history as set forth, which does indicate a criminal history score I as in ice? Ms. Norris?
No, Your Honor.
And Mr. Watts?
No objection, Your Honor.
Court finds no objection to the criminal history as set forth. Therefore, it does become one of the basis for sentence herein. Before proceeding to sentence, the court will listen to recommendations from counsel as to appropriate sentence, beginning with the state and Ms. Norris.
Thank you, Your Honor. Regarding the primary offense, the aggravated burglary, count 1, state would be requesting that the court assign defendant to 17 months in the Department of Corrections. Defendant would be able to earn up to 15% good time credit and would be subject to 24 months post-release if necessary. She has earned 3 days of jail time credit. Asked the court assign her to 24 months community corrections probation with all standard and PSI recommended probation conditions, including no contact with the victim or their property. And regarding count 2, Your Honor, the arson, asked the court assign defendant to 11 months in the Department of Corrections. Counts to run concurrent. Costs and fees of the action to be assessed to the defendant. Court will need to address court-appointed attorney's fees and the bid's application fee. This is her first felony, so she would be subject to the $200 DNA database fee. And Your Honor, there is restitution in this case. There is a $2,500 deductible to Varner Farms. Basically, they are the owner victim. And then $8,073.50 to Farm Bureau. That's what they paid out on the claim.
Whoa.
Otherwise, Your Honor, I don't think I have any further recommendations for the court at this time.
Was this a
Thank you, Ms. Norris. In review of the pre-sentence investigation report, I ran into a sum of $17,893. Is that irrelevant herein?
Amber, you're muted.
Buffering.
I don't have that documentation that refers to that number, Your Honor. I do have quite a bit of documentation.
Amber, that number comes from the victim's witness statement. Restitution.
Well, the victim's statement actually says 17,500.
Yeah.
Well, excuse me for interrupting, but on page 5 of the pre-sentence investigation report, that's where the $17,893 came from. In review, I only came up with Farm Bureau at $8,073.50 and the deductible of $2,500.
And Your Honor, again, are you talking about page 4 of the PSI?
I'm talking. Yes, Mr. Smith.
If I may, Your Honor, in the victim impact statement, which is all I had available at the time of writing the pre-sentence investigation, the restitution requested in the victim impact statement was $17,500. The additional fees that Your Honor is talking to are the additional fees for court costs and the DNA database fee, and those would not be part of the original restitution. However, I believe Ms. Norris sent out a lengthy list of pictures and information with an updated restitution total of the $8,073.50 to Farm Bureau and the $2,500 victim restitution.
And I also show that Farm Bureau Financial Services sent a letter June 11 of 2025 to the Butler County Attorney's Office. That's what I was keying to. It appeared to be appropriate as opposed to this 17,500 figure.
And Your Honor, that's why the state made the request that I did. Based, like I said, when the attached victim impact statement, the specific language and it says estimated at 17,500, but I think that was before everything was submitted to insurance, etc. And the individual that lives in the house is also not the owner of the house. She is I believe, a family member of the owners, which is a group of people, or at least the group is called Varner Farms, that owns the house that she lived in that was very damaged by the defendant. So I do believe I have provided the court the most accurate information and breakdown as of this date.
So the figure that the court should use for restitution would be the $8,073.50 plus the $2,500. Is
That's
that
correct? That's correct, Your Honor.
Thank you. I just wanted to clear that up. Thank you, Mr. Smith. Thank you, Ms. Norris. Recommendations from the defense, Mr. Watts.
Your Honor, the recommendations of the state are in keeping with the plea agreement. We believe they are appropriate. We would join those recommendations. I've also received the documentation regarding restitution. It comes with a very extensive photographic list in support of that restitution. We are not opposing that restitution. We ask to join the state to adopt the recommendations, Your Honor.
Thank you, Mr. Watts. Any further recommendations, Mr. Smith?
No, Your Honor. Thank you.
Further recommendations from Community Corrections, Ms. Ashenfelter?
No, Your Honor.
Thank you, Ms. Ashenfelter. And Ms. Joseph, prior to the court pronouncing judgment and sentence upon you, is there anything you would like to state in mitigation of your sentence?
No, everything sounds okay.
Do you know of any reason why the court should not pronounce judgment and sentence upon you here today?
No.
And Mr. Watts?
No, Your Honor.
Ms. Joseph, it is the order, judgment, and decree of this court that you're hereby sentenced to the care, custody, and control of the Secretary of Corrections, State of Kansas, to serve 17 months in prison. Court does grant you 15% good time credit.
Wow.
Court does order 3 days of jail time credit, and the court does order post-release supervision of 24 months if need be. The court does find that there is a presumption of probation in your case, and the court does grant you 24 months community corrections probation. This is as to count 1, aggravated burglary, severity level 6 person felony. As to count 2 arson, the court orders 11 months, Kansas Department of Corrections, and the court does order that time to be served concurrent with count 1. The court does impose all standard conditions and those probation conditions, costs, fees, and restitution as set forth on page 5 of the pre-sentence investigation report, with the court specifically noting restitution in the sum of $8,073.50 and the deductible at $2,500. So the court does enter that one correction to page 5 of the pre-sentence investigation report pursuant to the June 11, 2025 letter from Farm Bureau Insurance. Subsequently, the court does advise you pursuant to KSA 223608C that you shall have 14 days after the judgment of the district court to appeal your sentence. Court advises you pursuant to KSA 214619G of any expungement rights you may have, and the court does advise you of your prohibition of possession of any firearms. The court does make inquiry. Are you currently employed?
Pretty sure I just got fired because they took me off the schedule, but then nobody ever fired me yet. But I'm pretty sure I'm fired. Nobody's talking to me, but I'm not on the schedule. They're not giving me any hours.
Whoa. Do you have any money saved back to pay court-appointed attorney fees or bids application fee?
At the moment, I actually only have about $200 max, including my checking and my savings total.
Court finds that you are without financial wherewithal for reimbursement of court-appointed attorney fees and the bids application fee. Subsequently, the court does not order you to reimburse for those fees pursuant to the Kansas Supreme Court case of State versus Robinson. There is a very sizable amount of costs, fees, and restitution based on what appears to be an unemployment status of yourself. At this point in time, I'm finding that your reimbursement level should be at $100 per month, with that amount to perhaps be able to go up if you do obtain gainful employment and you do have appropriate monies available to increase that monthly payment.
All right, we're going to bail on this one.
Immediately after this hearing, I do order you to community corrections for you to meet with Ms. Stanfield or Ms. Ashenfelter in regards to the community corrections program.
All right.
Any other matters to come before the court, Ms.?
No, we're gonna bail on that one for just a second. We're gonna go back to Judge Middleton really quickly. Still no verdict. Still no verdict. But oh no, that's not the one. Not this one. Go to channel. He's live right here. Here we go. Okay. How about that?
All right, this man died, and they issued a warrant for your arrest last year.
Dice que esta persona falleció y el juez hizo una orden de arresto para que lo arrestaran, señor.
The warrant was issued in July of 2024.
La orden de arresto fue emitida el 24 de julio del 2024.
Do you live in Howe, Indiana?
¿Usted vive en Howard, Indiana, señor?
Sí.
Yes.
Do you work somewhere?
¿Dónde trabaja?
En Miller Poultry.
¿Cómo?
Miller Poultry.
¿Y de Polde?
Miller Poultry.
Oh, Miller Poultry.
Miller Poultry. How did you come to get arrested last night?
¿Cómo fue que lo arrestaron anoche, señor?
No fue anoche, fue el viernes de la semana pasada.
They arrested me on Friday last week.
In Indiana?
¿En Indiana?
Sí.
Yes.
Sí.
What county?
¿En qué condado lo arrestaron, señor?
En Howe, Indiana.
Howell, Indiana.
That'd be LaGrange. So did you spend several days in the LaGrange jail before they brought you to Centerville?
Lo dejaron varias noches ahí en la cárcel de Grange antes de mandarlo para acá, para Centerville.
Sí, me mandaron ayer miércoles me mandaron para acá.
Yes, yesterday on Wednesday they sent me here.
Okay. Do you have lawful residency status?
¿Tiene usted la residencia permanente legal, señor?
No.
No.
Where are you from?
¿De dónde es, señor?
El Salvador.
From El Salvador.
I have a concern about this, Miss Camfield.
Tengo una preocupación, señorita Canfield.
When I first looked at it, it was charged by the previous prosecutor, Mr. David Marvin.
El cargo lo hizo el señor David Marvin, el fiscal David Marvin.
This particular charge, driving with a suspended license causing a death,
Este cargo particular, manejar con una licencia suspendida causando la muerte,
it's called the Red Wings statute.
es lo que se llama el estatuto Red Wings.
A player on the Detroit Red Wings was killed in a circumstance like this, and they changed the law.
Esa es una ley que se hizo en honor a uno de los jugadores de Red Wings y se cambió la ley.
The section that he's charged under, 2579044,
la sección que le están imputando, que utilizaron, es la 27904.
applies to a circumstance when a person's license or registration certification has been suspended or revoked.
Esta ley se aplica a las personas que tienen una licencia suspendida o que ha sido revocada su licencia.
By another state.
Por otro estado.
Or operates a motor vehicle during a period of revocation or suspension.
O una persona que utiliza su vehículo mientras su licencia ha sido suspendida o revocada.
The driving record that I have does not show that this driver is suspended. It simply shows he does not have a license.
Correct, Your Honor.
Aquí el documento que tengo muestra que no tiene licencia, sino que no fue suspendida su licencia, sino que no tiene licencia.
So that issue is going to have to be resolved.
Entonces este problema tiene que ser resuelto.
There is another offense, which is a misdemeanor.
Hay otra ofensa que es un delito menor.
which is if a driver commits a moving violation and causes a death.
Esto se refiere a si una persona comete una violación al mover su vehículo o comete la muerte de alguna persona.
The affidavit says that this defendant lost control of his vehicle, crossed the center line, and hit the other vehicle, resulting in the death of Mr. Heyer.
Aquí dice que esta persona iba manejando del otro lado en el otro carril en sentido contrario, cruzó el camellón y se estrelló contra la otra persona, causándole la muerte.
And that is the charge the officer requested the warrant for.
Y este es el cargo por el cual emitieron la orden de arresto.
Mr. Marvin charged this offense, and I'm not sure it fits.
El señor Marvin está haciendo este cargo, pero no creo que esto se acomode al cargo que está haciendo.
And my office authorized the warrant.
Y mi oficina autorizó la orden de arresto.
I'll have to take a deeper dive into the statute, but this defendant, I don't think is suspended.
Voy a tener que revisar el estatuto, pero no creo que esta licencia haya sido suspendida.
Yeah, my records also show no license.
Los documentos que tengo muestran que él no tiene licencia de manejo.
Mr. Stickley, you didn't get an opportunity to talk with this defendant. Anything you'd like me to know?
¿Algo que le gustaría decirme, señor Stickley?
My main concern, since the court is limited in jurisdiction here anyhow, is that a bond be set fairly and equitably.
Lo que más me preocupa es de que se fije una fianza que sea justa y equitativa.
It's clear that this incident allegedly occurred quite some time ago.
Misconduct, thank you very much.
Es claro que este incidente sucedió hace algún tiempo.
I am unaware of any other criminal matters he may or may not have been charged with since.
No sé si él le hayan puesto otros cargos después de que sucedió este accidente.
So while this allegation is obviously very serious,
las alegaciones son muy serias.
I don't know that we can demonstrate a serious risk to public safety at this point.
No creo que podamos demostrar que hay un riesgo mayor para la seguridad del público en este momento.
Charge dismissed.
And I think it's more plausible than not that this gentleman had no idea that there was a warrant actually for him.
Y es posible pensar que esta persona no sabía ni siquiera que había una orden de arresto en su contra.
So for that matter, I would ask the court to entertain a low and reasonable bond.
Y por esta razón le estoy pidiendo al tribunal una fianza razonable.
I thank the court for bringing up the issue of how this was charged, which I was going to do anyway.
Le doy las gracias al tribunal por la manera en que se emitieron los cargos, lo que yo iba a hacer de cualquier modo.
I do think that community corrections could probably effectively supervise and intervene while he was out on bond.
Yo creo que la comunidad de supervisiones puede supervisar a esta persona mientras se encuentre bajo fianza.
And I'd like to reserve comment after any other comment that people make.
Y me gustaría reservarme mis comentarios
I'd like to go last.
Comentarios de la gente también.
Never heard
Ms.
that before.
Canfield, anything to add?
Señorita Canfield, ¿algo que le gustaría agregar?
If I could just have a moment, Your Honor, I'm looking at the most recent warrant manual for what would be an appropriate amended charge.
I think we might have a jury that went to
¿Me
lunch.
puede dar unos momentos? Estoy revisando la enmienda para ver si se puede enmendar el cargo que le están haciendo.
I'm not requiring you to amend it immediately. Just raise the issue. We can certainly deal with it between now and the pre-exam conference on September 30th.
Of course.
No estoy pidiendo que enmiende el cargo ahorita, simplemente que lo tenga en consideración para que se resuelva para el 30 de septiembre.
I'll just state that I disagree with Mr. Stickley that there's not a risk to public safety.
Solamente estoy en desacuerdo con el señor, el defensor, que dice que no hay riesgo de la seguridad pública.
We have an individual who is driving on our roadways unlicensed.
Tenemos una persona que está manejando en las carreteras sin licencia de manejo.
He has not demonstrated that he knows the rules of the road or can read the signage.
No puede mostrar que él puede leer los letreros o seguir las reglas de los conductores.
And pursuant to the report, it reflects he was driving too fast for conditions.
Y revisando los detalles, parece que él iba manejando muy rápido por las condiciones que había climáticas, ¿no?
That did in fact cause the death of another individual.
Eso causó la muerte de otra persona.
He is employed, so I think a cash bond is appropriate or surety.
Yo creo que es apropiada una fianza en efectivo.
I would also ask the court to impose a no driving bond
Said
condition.
effective instead of.
También le voy a pedir al tribunal que no le permita manejar un vehículo.
I'm concerned that he's not a lawful resident of the United States, and he is a resident of the state of Indiana, and he's a citizen of El Salvador. He may come to the attention of the Immigration Service. I'm going to set this. I'm sorry.
Lo que me preocupa es que él no es residente, no vive aquí en el área, no tiene la residencia permanente legal, no puede, no vive en Indiana y puede ser detenido por el Servicio de Inmigración.
I'm going to set the bond in the amount of $5,000 cash or surety. This case may become a misdemeanor.
Le voy a dar una fianza de $5,000 en efectivo y podría ser hasta un delito menor.
Defendant shall personally appear for any subsequent court hearings, including the pre-exam conference on September 30th.
Y tiene que presentarse a todas las audiencias que se le pida que se presente, empezando por la audiencia del 30 de septiembre.
He may not leave the state of Michigan, however, he may live and work in the state of Indiana, but no other state.
No puede dejar el estado de Michigan, pero puede trabajar en el estado de Indiana.
We'll just make it LaGrange County, Indiana.
En el condado de Grange County, en Indiana.
Shall not commit any crime while on bond.
No puede cometer ningún crimen mientras está bajo fianza.
Provide his contact information to the court.
Tiene que darle su información de dónde vive al tribunal.
Make regular reports to the court agency as directed.
Tiene que reportarse con los servicios de libertad condicional como se lo indiquen.
Shall not use any alcohol or any controlled substances.
We need to bail on that because we have something else going on right now. Back in Thurston. Let's see. Thurston County Courts. like it's possibly one of these. With 1 hour and 15 minutes roughly on the books, the court has been called back into session in Thurston County, Washington. This case with Emily Fogelman, charged with reckless driving, originally charged with 2 charges. 1 charge dropped on a directed verdict when the state neglected to point out someone else was in the vehicle with her at the time of this offense, allegedly. Less than 1 hour of testimony took place in the evidentiary portion of this trial.
I'm just going to go back upstairs, and then we'll continue to.
What? What? The judge says I'm headed back to my office.
Apparently, they knocked. Janice went over. They said, we have a question. Janice said, we need to put it in writing on that paper. And then they said, give us a few minutes. And then she went back and they said they're not ready. So what I was about to do, I told Janice earlier that I was just going to bring them in there and give them a lunch break at 12:15. Just tell them to come back at 1:30. Because, I'm not a big fan of can you reach a verdict, or if you can't reach a verdict in the next 10 minutes, we're going to lunch. I'm just going to say, just shut it down, bring them in, and let's do that lunch, which I'd be inclined to do now because it's 12:15 now.
Defense is in support of that, Your Honor.
Yeah.
Just say,
Personally,
we'll bring them back in. We'll be on the record, yes. You go with the decision.
Well,
scratch all that. Oh, that was terrible. I apologize.
Do something about soundproofing that room.
We need to not be able to hear the jurors. Well, that was a dry run. It was a dry run. I'm just showing you the sort of practice I do typically behind the scenes. That time you get to watch it.
Janice. Just bring him in. Don't tell him what's happening. Just bring him in.
I'm beginning to think he doesn't like Janice. Janice, don't talk to the jury. That's what happened to Teresa. You know how we got here.
Okay.
Thurston County needs to train their clerks. We had a trial where Janice was giving instructions to the jury. Janice knows Becky. Donna Turner, I apologize.
You can be seated in the courtroom. So, members of the jury, it's now 12:15. We're going to take a break for lunch. We'll be back in court you'll be back in the jury room by 1:30 to continue your deliberations. The instructions I gave earlier remain. Don't talk about this case outside of the jury room. Don't talk about friends. Some baby who brought lunch, you can eat lunch in there. That's fine. If there are other people want to do that, that's also fine. But don't talk about the case. Don't deliberate unless all jurors are present. You understand? Do we understand that? And we'll be back in We'll be back in the jury room to continue to deliberate at 1:30. That'll be it. You may go. She'll take you back.
Janice, don't explain anything to them, okay? Don't tell them anything. Set a timer for 1 hour and 15 minutes.
1 hour and 15 minutes, counting down.
All right. Somebody's vacuuming, which makes me happy because it's not me. We've stopped the timer.
Be back here at 1:30.
The timer is currently sitting comfortably at 1:20.
Wait.
We've had more deliberation time on this case than we had direct evidence testimony, including the video plays. They could have rewatched the entire trial during this time, start to finish, including the breaks for sidebar or anything else. I say we go to lunch, says Anisha. Well, just good. Let's see. I've seen guilty verdicts on murders faster than this. Were openings yesterday. They were. We missed them. They took them down. This might be longer than the Donna Hiddleston deliberations. What did the poll say? The poll's still up. We're going to close the poll right now. Great question. Thanks for reminding me. Poll, we're closing after, after 528 votes. We're going to end the poll. And it says this. It says, we got to 534 in the last minute. Okay, copy, paste. There we go. A little hard to read, but it says, did Emily Fogelman drive recklessly? The winner was, I need to see the dash cam first, 44%. The jury did see that. We did not. Yes, 31%. No, at 25%. If these numbers hold true, we'd have a hung jury. Which might make the instructions the defense attorney gave right before the jury went out to deliberate very, very appropriate and timely, saying, hey, don't surrender your belief just to reach a verdict. That would be inappropriate. Don't do it. Makes you wonder.
Welcome to the set of the...
Well, no, that's not where we're going. Welcome to the set of the live stream studio. These are the movies I watch on my break. Let's see. Let's go back here. Thurston County's out, at least for an hour. I've had my lunch. I mean, I don't know what you guys did, but I've ate. I'm done. Not sure what Judge Wolf is doing in Tennessee right now, but I hesitate to jump. He deals with some pretty tough issues, a lot of family issues as well. Let's see who this is. Judge Middleton, still going strong. I think Judge Boyd has a trial right now, the jury trial. Josh says, Buffer, don't go there. I looked at it, and it just looked like the wrong one to go to. So Judge Boyd doesn't look to be live right now. Man, I want to watch this one, but not right now. Can't. There's a cool video here from the guy. Let's put this on the save category. All right, there we go. It's about hardware and tech. You wouldn't like it. See, Judge Webster's live. Let's try that one. What do you think? Yay? Nay?
And
I'm in her seat.
I didn't get an answer from her, except I got a letter stating what I had paid. Well, I knew that. And she said in the letter, too, I should know what I paid. Well, I know what I paid. I was asking specifically in the voicemail what anyone else had paid. And I even called her alternative number that was on her recording, and they never called me back. And I called the person who was the accountant at that time, who is now deceased, and he didn't let me know anything because he didn't have a voicemail, and he wasn't answering his phone the days and the hours he's supposed to be there.
He could have been deceased.
So it was impossible to find out. I contacted Marcy. I got a letter from Marcy saying she is the next level of HUD management above the local level. And the letter said, if I moved, I would owe nothing. If I came back, I would owe. Well, it really didn't tell me a specific amount. So I just continued to pay the rent, which was 197 before, then it was reduced to 205.
What? That went up.
And there were some injuries which I didn't do anything about because I realized that in Madison there is a revenge culture. First of all, shortly after Eric started, which was about 2 years ago,
Revenge culture.
I was walking under some trees and a branch fell on me.
We're in
And
Kansas.
he had been cutting branches some days before that, so apparently this branch was laying on top of the other branches and maybe wasn't noticeable because there was still leaves on the tree. And I didn't say anything about it, and I was in pain for months off and on, but I didn't want to start with the chiropractor. Sometimes injuries sort of heal themselves. And then another time, there was a slanty sidewalk going from the apartment where I've been renting to the edge of the property.
Those slanty
And I
sidewalks
walk
are
on
the
that
worst.
sidewalk sometimes, and there was some water on the sidewalk, and I walked where there wasn't any water, but somehow because the cement was damp, one of my feet slid into the puddle, and then the neck injury started again with pain. But again, I thought, well, maybe this will get better, and it gradually got better, and sometimes it's worse. If I walked a lot or carried a lot, it would get worse. But I didn't want to start with the chiropractors. We have a very good one in Madison, but she relocated and is only in Madison once in a while. She doesn't accept insurance. It's $100, and I just didn't want an extra expense. I preferred to tolerate the pain, hoping that it would cure itself. Then a third thing happened. I was walking to Joyce's apartment because she's a friend, and
Oh, Joyce.
there's a metal
We like
plate
Joyce's.
apparently covering a pipe that was somebody put there for some reason, probably for drainage. And that metal plate had grit on it because some of the other metal plates have some grit. Well, the grit is totally off that metal plate going to her apartment door. And I slid on that, and then my neck injury got worse again. Then the fourth thing that happened was when Eric moved the refrigerator, he was just really mad. Like, I have never seen him that mad before. But anyway, I had a china cabinet that was near the path where he was going, but it was just too much into the path, like maybe a few inches. So he moved the china cabinet at an angle, but I couldn't get at the AC then. And before he left, I didn't think of asking him, can you move it someplace else? And so I tried to budget, and then that made my neck worse again. And since then, he did stop, and I asked him to move it to a different spot. He did move it to a different spot. So it's out of the way of the AC now. I did comply with their notices. Eric did not get a call from Kyle. He called her. The flies were only in the fridge and the freezer. There were a few that flew out, but they were like almost deceased because they were just flying really slow. There was no trash in the refrigerator part. He said there was trash in the refrigerator. It was in the freezer. And I did that because it was food wrappings like the trays from Meals on Wheels. I rinse them out, but still, to prevent bugs, it's better to either take the trash out every day or otherwise put it in the refrigerator or the freezer so that I don't have any bugs. And I didn't have any bugs until this happened with the refrigerator. What else can I say? There's more for me to say. I did take the trash out, except sometimes I ask someone else to take it out. Oh, I know what I wanted to tell you. When they originally designed the floor plans, the buildings where they would go, where the dumpster would go, those designers were probably not senior citizens because there's three ways to get to the dumpster. One is walking over gravel, the other one is walking on lumpy grass with tree roots, and the other one is walking on slopey cement, and that is difficult for a senior citizen. There's many there who walk with the walker, and sometimes I walk with the walker, but I try not to. And so it's difficult for senior citizens to even get to the dumpster. Other people have told me the same thing. And then there's a problem with the sidewalks, this slanty one, and also there's a big hole between the seams of the sidewalk in front of the fence where I'm living. And somebody from HUD was there when they had their last meeting about some people from HUD inspecting the apartments. And she told me that the HUD inspector said there's nothing wrong with the sidewalks, but some are uneven. They did patch some over the years, and then there's that big hole in front of the fence where I'm living. And I'm hoping before I move that they get these fixed because I don't want my movers to trip, and I don't want to trip. And there's also Now this I never mentioned to Eric, I just didn't think they'd do anything about it. But on the doorway, going to the outdoors, between the outdoors and the door sill, there's about a half an inch drop off. And indoors, there's about an inch from the door sill parts to the living room floor. And I have to always make sure I walk over that. Well, somebody else, if they're busy moving, they might not think of that. It's a hazard for other people. It's a hazard for me. I tripped on it twice this month. And then, so that's the part about the sidewalks. I'm asking for this eviction to be canceled. I've been told that I will not be able to rent another HUD apartment for 3 to 5 years if I'm evicted. And also there was sex harassment apparently. Eric was itching himself many times when he was around me. And I didn't say anything about it because of the revenge culture in Madison. But Eric was a lot of lies and exaggerations. He's got a full-time job, and then he's got all this with these apartments, and it's kind of maybe overwhelming, according to what he told me originally. I don't know if it still is. And then regarding calling him late at night about the snake, I called him during the day about the snake. But at night, I did call him because
different snake.
There had been a flood from another apartment, and the toilet before that flood was making funny noises.
From the snake.
And so when it started making those noises again, or I should say strange noises, not funny. And so when it was making those noises again, it was 10:30 at night, I did call him and tell him, and he said, well, I'm not going there this time of the night, and it was hostile. But he did show up 15 minutes later.
We've run out of
and then
song.
He stayed a few minutes, he looked at it, he said, well, there's really nothing he can do. And then later he told me that I called him after 11 o'clock. Well, by the time he got home, it might have been 11. Jack is not my husband. No. He has not passed away. His voice was on my phone. I've talked to him in person, but he was a passenger. I think that was my sister driving, and she drove away. He wouldn't answer the questions. They have him intimidated about contacting me. But he is alive, and he's not my husband. We were engaged the last time I talked to him when he was in a hospital. And he's not passed away. This group that's been harassing me for probably, I think 24 years. Somebody told me 25 years.
Spencer's counting.
They did something similar with my dad. We got a letter. My mother and I got a letter saying that my dad had died, and it was on official government-looking stationery. And I called Social Security, and they said, we can't tell you where he is, but he is alive. And then we got a bill about wound care, and I thought, well, maybe he's in a nursing home. So I called the nursing home where I thought he would be, and he was there, and we visited him a bunch of times before he did die. So because they had done this with my dad, I thought maybe they did this with Jack, and I had gotten many messages months after I got the death certificate that Jack was alive. And now I've gotten a text a few months ago that doctor died. Well, I don't know what kind of doctor. I thought, what kind of doctor could this be? Maybe it's the doctor on the death certificate, that it was signed after he was deceased, and I have to call about that and find out when did that doctor die, and is he still alive? But anyway, his ex-wife worked in a nursing home, so she had access to all those kinds of papers. Also, what Eric said, I kind of got off and attached.
Excuse me, I want to make sure I'm not confused here. Are you talking about this Jack or your father right now?
Oh, I'm talking about Jack is not my husband. And okay, that I had gotten that.
He had been your fiance. Jack had been your fiance.
Right.
He is not dead, but you said something about a death certificate. Could you clarify?
Yes, his ex-wife sent me a death certificate, and I have it with me as far as I know. And there's a doctor's name on it. And then I got a text a few months ago, doctor died. And I thought, what kind of doctor could this be about? It must be about the death certificate. And I've got to call and find out if that doctor was alive, or did they sign his name after he was deceased. But I'm sure that was Jack. That day I got a hint, that he's going to be driving around, he's going to be a passenger, whatever, just that he was going to be on a certain road, not the details. And so I waved my arms, and they stopped, and I tried to talk to him. He wouldn't say anything. Well, my sister, I think it was my sister, was answering for him, and she drove away. So, but I'm sure that was him. And I do not have a cat. I don't know where Eric got that from. I never looked for a cat. Never. We have 11 neighborhood cats that roam around different times of the day and night, but I do not have a cat. I had a cat years ago before I moved to Kansas. And regarding the school, I went there to ask about their plant sale and about buying eggs. And that was my reason for going there. And regarding the flashlight, I didn't shine it in anybody's apartment. I was shining it on the sidewalk when I was walking at night.
Looking for cracks.
And regarding getting into apartments, there were some people who invited me into their apartments when they were there. You know, some I helped, some they just wanted to tell me their problems, whatever.
Yeah.
And one time I was knocking on number 2 because I kept on getting these messages, something about Jack and number 2, and we do have a number 2. And like Eric said, he was right about that. It's empty. I've never seen anybody go in and out of there until recently, except him. And so from a distance, a certain tenant, and I don't know, are you a lawyer? Because I'm only supposed to tell names to lawyers. That's what a lawyer told me. Anyway, you are a lawyer. All right.
I'm a lawyer, but I'm serving as a judge at this time.
Yeah, so I can tell you because you're a lawyer. But maybe also because you're a judge. So the certain tenant, Sandy, was way at the other end of the property.
Don't tell
like about 1, 2, 4 apartments away from me. But she was next to another building. And I was knocking on number 2, and she yelled at me, "You're trying to get into number 2." And I said, "No, I'm not. I'm knocking on the door." And she kept yelling it. And then another time when I was outside, Eric was about in the same area, about where Sandy was standing. And I was knocking on number 2, and he said, "You know, you're getting into number 2." And I said, "No, I'm knocking on the door." And we went back and forth on that. Anyway, so that's that part.
Page 2.
And he said that I put notes on the doors of the new tenants. No, it's not every new tenant, but there was a new tenant some months ago, when it was cold yet in the spring. I noticed that she had a teenager visiting her. I thought maybe that's her grandson, and she's not outside very much. So I put a note on her door saying, "I'm looking for somebody to hire to throw out my trash." And I wondered if the boy who visits her might be interested. And it's not all the new people that I put a note on their doors. It's just that I did that for her because she had the visitor who looked to be the age of a student who would like maybe a small job. So that's that part. And I did ask one tenant for a ride, but I had listened to him talk lots of times. And he did, when the transportation program was shut down because they couldn't they had troubles with their van and they couldn't get another one. They could get one once in a while, like a few times a month or once a week, and it was only certain hours. And so I needed a ride. So I did ask one tenant for a ride, and I did give him things. But anyway, I asked him if I said I could pay him. He said no. And I've never gotten aggressive with any of these people. With Eric, though, he harassed me so many times, and there were threats, which makes it domestic terrorism.
Yep.
But I just let it go. And he was aggressive to me. He had a hostile voice sometimes, but I was not aggressive to him. But I did talk back to him the last couple times.
What'd you say?
Like, for example, I asked him to fix the blinds because the blinds in the living room, they broke at the top, the piece that goes across the top. And what he did was he fixed it sort of temporarily. He was looking for his electric drill and he couldn't find it. So he used one of those cable ties, tying it to some other part of the blind. But then I could only raise it about 3 or 4 inches. And then I went outside because he was still around, and I said, "Could you do something with the blind so I can raise it more?" And he said, "Well, we'll see." He was talking to somebody else as if, I was just a tree or something. And generally, sometimes his attitude is very good. Whatever he does get done, he does a good job, but not with the blinds. And then the other blind, they're probably very old. They look very old, and they don't last forever. In the bedroom, there's some pieces missing. And I asked him if he could maybe switch it with one from another apartment. And he said, "Well, they're all smoky. But when they ran their ad, they put smoke-free in the ad." And then he said, "Well, if you can find the pieces," that time it was only one piece, then he said, "I can fix it." Well, I found that piece because I had saved it. And then in the meantime, it broke in 2 other places. So I said, "Well, I have all the pieces. Can you fix it now?" He said, "No, fix it yourself." And then when I was talking to him about the living room blinds, he said, "I broke it." I said, "No, I didn't break it." And he just kept on. He said it 3 or 4 times. I think 3 times, you broke it. I said, no, I didn't break it. It broke itself
Then he
when I was
itched.
trying to raise it. And I mentioned about the trash that, why I put the wrappings in the freezer.
That makes sense.
And then there's some other parts. So regarding, there's some other parts that I wanted
Eric's a
to
maintenance
address.
guy. There's some other parts.
This part says harassment of board members. I did not harass any board members. That is a misstatement. A board member helped me to move there because I had called his church. And he did it with a good attitude. He found 2 helpers. And so somebody gave me a sofa, but it was very scented. And I knew I couldn't tolerate it. So I called him and I said, I have a sofa I want to donate. Could I donate it to your church? Because he had said to me, they have a building where they store furniture to give away. And he said, well, right now we don't have space and I don't have anybody to move it. So I called him back about twice a month, or I voicemailed him. I did this for maybe 2 months. And finally he did show up and they did take the sofa and he had somebody to give it to. So that wasn't really harassment. But then because I knew him and I didn't know who else was on the board, when this rent issue happened, where I was told that someone had paid part of the rent, and then this was on my anonymous text board that I created that I mentioned. And then I said, well, I haven't been able to find out how much was paid.
We missed that
He
part.
said, I got the answer back, plenty was paid. Then when I couldn't find out from, he's threatened that if he does anything for me, something will happen to him. And I asked different times, well, what are the threats? And he wouldn't tell me. Then his icon showed on my text, part of my calendar, and it looked to be a gun. And then some days after that, the word shooting was in a text. So he's been very threatened about this. This, I think, is Jack. And he's been very threatened that if he re-meets me, I think he knows where I am, but I know sort of where he is, but they keep moving him around. He's a slave. And I couldn't find out from him. I couldn't find out from the person who helped me move. So then when we had this flood because of another apartment,
Eric is so dumb.
I called that person and told him about the rent situation. And well, he said he would try to find out. Well, then he called somebody else. And then I got a letter from Attorney McIlvain, and then I also got a letter from Marcy.
Cease and desist.
But it just said what I said, that if I leave, I won't owe anything. If I come back, I will. So that was the situation with the rent. And I don't know if they call this harassment. I was just trying to find out information. Then this part about other tenants. Sandy smokes, and I mentioned to her that her smoke was getting in my apartment. And then somebody told me, oh, she doesn't smoke anymore. Well, I smelled the smoke even after that. And I asked her, could she open her windows? And she said, well, I can't tolerate the wind. She does open her screen door sometimes, like maybe 4 inches, and then she lets her indoor door open at the same time. And it's happened a bunch of times. Sometimes it's many times a month, sometimes it's once a month, some months not at all, so it's random. And so when I didn't get any results talking to her, I thought, she's smart, and I'm going to write her a note. So I wrote a note about the same thing. And maybe they call that, I got a notice that I was trying to enforce the rules. Well, if they don't enforce the rules, I guess I don't have any right to enforce them either. And I didn't ever harass Eric. When he would harass me, I would just say nothing, or I would be polite. And except the last couple times I did talk back to him. And contract assistance, that would have been about the spraying, I think. I did call and I told them I'm very allergic. Could they not spray? Because I got a notice that all were going to be sprayed. And they didn't tell me anything else. They just said, we will not spray your apartment. And this harassment it's a misnomer. It shouldn't have been called harassment. It could have just been contacting or something like that. But I didn't feel I had any other alternative. And then another thing was when I filled out the papers to renew my lease, the first time. The first time, that was one time. Then I renewed it, and then I had to renew it again. And the second and the third time, there was a page saying, did I receive these different pieces of information? And some of it was the numbers that were on the pages of the lease agreement. And those I checked because, they just gave them to me. And yes, I did read them. I read all that fine print. And but then there were some others that were not part of the lease agreement, and those I did not get. When Eric gave me the copies back, there's a big red check in front of those that I did not check. Like they want me to believe that I got what I did not get, but it was all about tenants' rights. So they want me to believe that I have no rights. And then calling companies requesting work orders, that would have been about the spring. And companies is a plural here. It was only that bug spraying company. And then trying to get into other units, I mentioned that. Now getting to this page starts at the top, bothering other tenants.
Page 3.
I didn't bother them. I nicely asked if they could plug in my phone when I didn't have electricity so I could call about electric assistance, etc., and that I could pay them to do that. And they said, yes, we'll do that. A few did say, no one said no, but they did that. But then they didn't want me to pay them. And I didn't use a flashlight to look into other apartments. Like I said, I was just walking on the sidewalk. Some of these notices I get are that if I look outside at night, Jack is going to be there, but he isn't. And then this part about at least 4 times I needed to have her door unlocked. There were 4 times. He was accurate about that. But some of them I didn't even tell him about. So the first time was when Zach was the maintenance man, but we were, well, how can I say this? I called Donna because she's in the senior projects office, and I figured she probably knows somebody who could unlock my door or remove a screen, whatever. And she recommended her grandson, Zach. Well, I didn't know that he was working for the project at the time, the HUD housing project. And so he took the screen off, and I said, I can pay you. He said, no, you don't have to pay me. I said, I'm paying you. I gave him $10. And he was really good about getting there quickly. He got it done quickly. He did it with a good attitude. All those things are important.
5 stars.
And then the second time when I got locked out, I called Eric. By then he was working there as the manager.
Eric's the
and
manager.
He said, well, I'm out of town. I can't do anything about it. And so I went to a church, and church had not started yet. And I asked a person there, could he remove the screen, and then I would pay him. He removed it, I got in, but he didn't want me to pay him. Then the third time, Eric did take the screen off, and he said to me in a really hostile voice, it was a threat, it was domestic terrorism. If you lock yourself out again, I'm going to charge you $25 to take this screen off and put it back on.
That's terroristic.
And so he took it off, but then, he threatened me at the same time. And the fourth time, and this is, I've been there 27 months. I'm just thinking May, June, July, August, September. Almost 28 months. And
of bliss, pure bliss.
The last time, he happened to be working in an apartment 2 apartments away. So I just went and asked him if he could unlock the door. He had his keys with him. He unlocked the door. So it's like he's making this into a big deal. Other people lock themselves out too. He wanted me to put a key on the patio. Well, a lot of people probably do this. I've heard other people tell me they did this. I don't think it's really safe to put a key on the patio. I've had so much disappear. I'm going to talk about that next. Well, first I want to mention Eric is good in a lot of ways. More. If I was evaluating him, half the time I'd give him an A+, and the other times I'd give him an F-. So whatever he got done was done very well, except for the blinds. And there was something else I was going to say about Eric. Let me just think a minute. I told you about the doors being unlocked.
Domestic terrorism, sexual harassment.
I told you about the injuries.
Very hostile.
Well, if I think of it yet, I will say it. But there was one more thing I wanted to say.
What's crazy is this is happening right now in Kansas as we speak.
There's times when he has threatened me. Like he said, if I don't get RCIL to help me with the LEAP application, he was going to get me evicted. I would get evicted. Well, there's reasons I don't want to work with RCIL. I've heard about their employees. They're not always good. And also I called RCL though, because of his threat, and found out that a person has to be on Medicaid in order to be eligible for their program. And that takes time to process. And the last few weeks, it takes a few weeks just to process it. Then it would take them time to find somebody, because when a former tenant was looking for someone, it took them months, because Madison's a small town, people didn't have transportation, they're very fussy about who they hire. So I just didn't think there was time to do RCIL, and I didn't really want to do RCL. The other thing they told me is they require not just a small project like clean the floor and clean the refrigerator and take out the trash once a week. And the trash would be a weekly thing. The other things are one-time things. They want somebody who can work a bunch of hours every week. And I don't have anything else that I would want help with. It was just those three things. And I'm still in the process of looking for somebody about the trash. But I did take it out most of the time myself, or I found somebody to do that. You know, he is making it sound like I never took it out. It gets to be 1 or 2 bags, and then I either would take it out myself or I'd find somebody to take it out. And then there's this issue about things missing. A short time after I moved there, like a few days, I noticed that there were footprints on the floor. They were not there when I moved in. They were muddy looking, and they were pointed toes like cowboy boots.
Like Eric was.
And I didn't say anything to anybody because I know Madison and Kansas has a revenge culture. Yes, and then I started missing things. I am missing probably equal to 4 months rent in 28 months. I mean, as far as replacing things go. And I didn't report it because of the revenge issue. But another tenant is missing things also. And I asked her, well, what's the value of what you're missing? She really didn't know, but from what she told me, I would say between 100 and 200. Another tenant who moved had her apartment broken into, and
objection here.
They cut the screen, whoever it was, and they got into her apartment through the inside door then. And she got a device that would make a noise if anybody tried to get in. And she was just so tired from having a new baby that she didn't set the alarm one time. Another time it went off, and when she got to the door, they were gone. They apparently got scared by the alarm. But she was missing. Now, this person she said was her dad. I talked to him and I said, well, how much is she missing? What's the dollar value? He said $3,000 because she had 7 orders that were supposed to be delivered and she never got them, and the company would not reimburse her. So anyway, you know, it's not just me that's missing things, it's these other people too. And it's things that, like, I had multiples of, like my food or my plastics or my paper products and some other things. So
I'm just here for Eric.
And then I got texts telling me that there had been tampering done. And I know that that could be possible because it was done other places. And based on how I felt, yes, I think that did happen. Probably the same time things disappeared. Like I had, my guess is about 10 cans of pumpkin. All of a sudden I have only 1 and I didn't make any of them. That's just one example. But, you know, adding everything up together, I'd say it's equal to 4 months rent, including the suitcases that are missing. I had 23, plus I got some extra ones. I'd say half are missing, like 10 or more. And
23
it's what
suitcases?
The value of replacing the suitcases, but what's more valuable is the papers in them, because this domestic terrorism case is, it's federal, and I needed the papers from all my suitcases in order to prove all that's happened.
She's taking her case to court.
And so how do you put a value on papers that a person needs for a federal case? So I didn't even include that. I just included what it would cost to replace things. And I was replacing things often. And the more I complained about it to the bugging system and on my calendar app, the less it happened. You know, that's my situation with things disappearing. And I think that's probably a summary of, I'm asking that the eviction be dismissed, or that I get more time to move. I have lists of about 70 offices. Some have been contacted that would help with this in one way or another.
70.
Either with finding a place. I would have to move where they can't find me, because if they find me, this group, they just create problems wherever I live. And so there's lots of different pieces to this. And also, I don't want assisted living. I don't want an organization or agency running my life. There's sleep starvation. I woke up so many times during the night. I get an average of about 5 hours of sleep. I'm surprised I can even tell you all this. And sometimes it's only 3 or nothing. Sometimes, a few times since I've been there, it's been 8 or more. But I'd say the average is about 5, so it's really not enough REM sleep, which you probably realize being an educated person, and even people who didn't go beyond high school probably have heard or read that REM sleep is really important. So yeah, sometimes everything I told you I think is relevant in some way to this entire situation. So I think I've covered all the bases.
All the basics.
All right. You said that you did not want the eviction, but in the alternative, you would want time to move. What kind of time were you talking about?
I wish I was a fortune teller. A month would be good if possible.
Okay. All right. And this group you keep talking about that you're concerned about them, with their effect on you. Who is this group of people?
At the root of it is priest abuse. A group of priests in Wisconsin wanted me to get involved with them. And I didn't want to. And so I thought it would fizzle out. And I tried to solve it. But in the beginning, attorneys told me it's not terrible enough. Later, they told me it's too terrible. They've done everything they can from A to Z to deplete me in every way they can. A lot of it was moving around and also trying to split Jack and I as many times as they could. And now with all the threats to him and the fact that he is a slave now, or he was very recently, I believe they're at the root of it because I've been told that it's the same priest leader as what Wisconsin had. My sister's involved in it. And now here in Kansas, there's other people involved in it. So basically 2 from Wisconsin and the rest are, new people. I
think she needs help.
So that's the group. They just, it's like a punishment that I don't want to be involved with them. And my concern, I don't want assisted living. I will only get help from whoever I think is not going to be bribable by them or whatever, because the threat to me near the beginning was they were going to make me look like a criminal or make me look crazy, and my only way out of an institution was going to be to join their group. And I have avoided them. I've done everything I can, but it's like too much of my life revolves around trying to go around the problems they try to cause or solving the problems they try to cause. It's difficult to make any headway that way. So I have to get at the roots of this too, which off and on I tried, but I didn't get results. But now I have these almost 70 offices, and I'm hoping that some of them can help with some part of it. And I'm not mad at you. I may sound, like I'm mad at you, Judge, Your Honor, but I'm not mad at you. You're trying to get justice. It's all these things that have happened, and I'm not being aggressive. I don't think I'm being hostile. But I'm just, telling you how it is.
Okay, I understand. Well, I have one more question, and then I'm going to let Attorney McIlvaine cross-examine you.
Oh, wow, we're still on direct.
If this place is as bad as you're telling me it is that you're living in, why do you want to continue to live there? Why are you fighting the eviction?
Because I don't have another place to go to yet.
Okay.
And because I realized from what I was told before by other people that if a person is evicted from a HUD apartment, they cannot rent another apartment. I heard 5 years. Then I heard 3 to 5 years. Then I heard once in a while they make an exception. But I can't count on an exception, and that's really all I can afford. And, this is an important point. I'm glad you brought this to the attention of the court. I had 20 jobs, and I was wondering why my Social Security is so low. I'm getting the minimum amount. That's the problem. And I asked many times. I called Social Security many times, and nobody would really tell me any kind of a definite answer. And then finally, one person was honest with me, and he said, your employment records were mainly destroyed. My employment records were mainly destroyed. So I wonder if the group is at the root of that. The Catholic Church has a lot of connections and affiliations, and so on and so forth. Like, why were my records destroyed? I never read or heard about anybody else's records being destroyed, but they maybe don't publicize that. So that's why I'm getting only the minimum amount. So I have to address that issue also. And I can't appeal it. It's difficult. I have a list of the jobs that I had, but many of my bosses were older than me at the time. And so would they still be alive? Would they be reachable? Would the company still have the records? One company where I worked a long time, the building burnt down and probably the records with it because it was a wood building. I was told it's very difficult to prove. At this point, I saved my check stubs, but I think my mother threw them out because I don't have them. So whenever I talk to somebody about this, I like to add, I hope that anybody who hears about this saves all their check stubs because anything can happen. And that is the proof. So, and their tax returns also.
All right. Well, thank you very much.
I'm guessing no questions.
Ms. McElvain is going to have the
redirect.
right to do what we call cross-examination. You probably know about cross-examination. So go ahead, Ms. McElvain. You can ask her the follow-up questions.
Yes, she had said if that you would want 30 days to move. So would you be willing to be out by October 15th?
Yes, I would.
No further questions.
And that means you'd be out in all your belongings.
Right, and I would have the apartment cleaned. I heard that, this was months ago, like a year ago, I think, from somebody that nobody gets their security deposit back. But then I heard that person got hers back.
Yeah. So there's a provision in your lease that talks about if your security deposit's not going to come back, that there has to be notice and then you have an opportunity to follow that up. Are you aware of that's in your lease?
Yes, I am.
Okay. And a couple other questions. Was your electricity turned off recently for up to 28 days?
It was turned off, and I would have to count the days. I thought it was 25.
Okay. And do you understand that that's a violation of your lease not to be paying your utilities?
I would have to read the lease over again.
So you don't know if it is?
Not 100%. I mean, I've been told that it is, and if that's accurate information, then it is.
Okay. And do you understand that when your rent is determined, that part of that determination is giving you an allowance to pay your utilities?
Yes, I understand that.
Okay. And when this refrigerator was removed, is it your testimony that it could have been cleaned and repaired and there was not bugs or mold in the motor?
I don't know if there was mold in the motor because it wasn't disassembled. I don't know if there was bugs in the motor, but the cleaning person who does cleaning as a job thought that if it was cleaned, it would work.
Okay, who was that cleaning person?
Her name was Connie.
Connie what?
I don't know her last name. Somebody else found her. So I don't know her last name.
So, but she came and looked at the refrigerator and tried to clean it?
Well, she looked at it. When she opened the door, she noticed some bugs. So then they went and got some spray and they sprayed it and then came back some days later.
Did I understand your testimony that it was sprayed like maybe 4 times?
No, it was sprayed only once. That 4 times was about the door being locked, that I didn't take my keys with me.
Okay. So when you mentioned that this refrigerator that was hauled away, that there'd be some clunking noise, did you ever file a maintenance report about hearing clunking noise on your refrigerator?
No, I didn't.
Okay, thank you. And
when I told Eric that the heater AC was making a lot of noise, he said, well,
yes, I heard that testimony. I was wondering if you had ever made are you aware there's a procedure, because I think you've used it before, if you have a complaint, you can write it down and put in the black box and then it gets addressed?
Right.
Okay. And with regard to this refrigerator, your testimony is that it was not ruined.
I think that it was fixable. And I also think it was ready to conk out because of the clunking noises. I mean, that it would happen really soon.
Okay. And your testimony was that you were putting garbage in the freezer.
Well, I wouldn't call it garbage. It was wrappings from food. And I did that to prevent bugs and also because of my allergies. And it wasn't a lot. There was still some frozen things that had been frozen in the freezer. And there were some things like the brown bags that the food came in or the trays that the meals arrive in that I rinse them out and so that they're totally clean, but still they could be scented. So then I put those in the freezer.
Okay.
Because there was space.
So are you aware in the lease that that there's other tenants up there and they are to have a right to their quiet enjoyment and use of the property?
Yes.
And by going to these tenants and asking them to use their electricity or asking them to take your garbage out and on a consistent basis, is that allowing them an enjoyment of their property?
Well, it wasn't a consistent basis. The electricity asking them if they would charge my phone was only while I didn't have electricity.
So that would have been, so just to follow up, that would have been a 25-day period at the last time, is that correct?
But it wasn't every day because the charge would last some days.
Okay.
And some days I didn't ask, I just did without the phone. And I needed the phone in order to call about electrical assistance. And I thought of what else I wanted to mention regarding LEAP. Eric did a really good thing by dropping off the application, but he said that I called him on a Saturday, I called him on a Friday. The office closes for the weekend, and I called him before the office closed on Friday, and it was due on Monday.
Let me follow up on that. Is there any requirement under our lease agreement that Eric provide you a LEAP application?
I didn't notice anything like that, but he just did this out of the goodness of his heart. But he made it sound like I called him on a Saturday, which is 2 days before it was due. I called him on Friday, and he harassed me a different time and said, "Oh, it's the last minute." Well, it did get done. And if I wasn't so starved for sleep because of all the noise harassment, it would have got done sooner.
Okay.
Her mind
Your
is
Honor,
sharp.
I don't have any follow-up questions
She needs help
at this point under the condition that if she agrees to be out by October 15th, then I don't think that there's a big issue for us to go back and forth about whether she should be evicted or not evicted. And I think that could save us a lot of time and maybe some embarrassment in this situation. With regard to the refrigerator, our claim regarding the refrigerator still stands. I think Eric's testimony was more than credible of the condition that it was in when it was taken out. I was there when the replacement used refrigerator was put in our apartment, and the apartment then still smelled bad, excessively bad. And at that time, it was going to be moved back in the kitchen, and she told Eric not to put it in the kitchen because it hadn't been cleaned, and it was still a mess. So the Pleasant View Village works on a very low operating budget, and we can't afford to be replacing refrigerators if our tenants have the utilities turned off for 25 days at a time and cause a situation to arise. So if she'd agreed to be out October 15th, and if we could, we'd ask that you consider having us keep her deposit for the refrigerator, and that if she's not out by October 15th, that we be granted restitution to have her set out, then I don't have any other questions to ask at this time.
All right, so Ms. McIlvaine, the cost to buy the new refrigerator, do I understand correctly that it was $799?
Well, it was $599. And then it was we pay Eric, and we pay him for the time to remove the old refrigerator and then to transport away. And then we pay him, he actually was paid to find a different refrigerator and to have it moved and ready to come in yet. And that $100, the $100 has not been incurred yet for moving it in because we did not move in a new refrigerator given her situation.
So when I read, you're asking for a total cost of $799 to be reimbursed, that is taking into consideration the cost of the refrigerator, putting it in, taking it out, and you're asking that her $264 deposit be applied towards that $799 and other costs if necessary?
Yes.
Okay.
And then an order of restitution that if she's not out, just to avoid us going through this on a continued basis, we'd ask that we have an order of restitution in the order.
All right. So, Ms. Vojkovic, do you agree with Ms. McIlvaine that you can and will be out by October 15th?
Yes,
we don't have to, so we don't have to argue. And Ms. McIlvaine, as I understand it, her big fear, Ms. Vojkovic, is she doesn't want to be evicted so that it would affect her future HUD. What is your position on that concern of hers?
Eric,
if she agrees to be out and is out, would that be a problem for future HUD, or do you know?
I don't. Eric, I think, can comment about. He's shaking his head. I'll let him comment about that real quick.
Mr. Holmes, do you know how that would be effective?
There's no provisions in HUD about if you're evicted that you'll never receive HUD again. It's up to each place's own discrepancy. It's just like if you were going to go rent an apartment, that they'll run your background and they'll see that there's an eviction on there, and then they can make a decision. I got somebody up there that's been evicted off of HUD right now. So there's no provisions in HUD that states that they will not be able to receive HUD for 3 to 4 years. I looked it up twice since we've started this the past 28 days just to make sure, because I knew that was going to become a thing. But it's a case-to-case basis, and it's a judgment of when I meet the people, I interview them, I say, oh, this is a good candidate, blah, blah, blah. Her background comes back, well, she's got eviction. I'll go ask them about an eviction, what happened. And so then I say no, and then I make a trustworthy judgment, and it's up to each place that does that. There's no, they can't. If they did that, you know how many people would be homeless, you know?
So someone may genuinely have told her that if she gets kicked out of HUD, she can't get another HUD for so many years, but that person may not have known what they were talking about, or they could have had that experience, but that would have been based on who they were trying to rent from, individual. All right. Does that make sense? I don't know what the rule is about that, frankly, Ms. Vojkovic, but do you understand that person telling you that may have been acting in good faith but confused because maybe they, for instance, tried to rent for someone that told them that, but that may have just been that facility's individual policy and not a federal policy or rule or something?
I would like to ask if Kyle Engel could speak to you, because she called and asked. She called KHRC, and you probably have heard of them, and she would like to tell what they told her.
Well, it's your case. If you want to call her as a witness, you can do that. But I understand Ms. McIlvaine is saying if you're out by October 5th, we'll go on
October 15th.
October 15th, and you're not going to consider that a forceful eviction. It would be a voluntary leave, Ms. McIlvaine, or what would your record show if you could say?
Well, our order would say that that the order that you just found that during the hearing that she agreed to be out by the 15th, and that you didn't have to make an order of eviction or a wrongful detainer. And it would also show that if she wasn't, then we'd have this provision to be able to go forward to set her out. But it wouldn't have to say that she was, quote, evicted. It would just say that during the hearing, the court, that there was an agreement between the parties that she be out by October 15th. And as we feel it's in her best interest to do that, and if she doesn't like it up there, but also just considering everything that's happened with her, and it's certainly in our interest for the benefit of our other tenants to have the situation resolved for everybody.
All right. Well, what do you think about that, Ms. Vojkovic? Do you think that makes sense? Is that something you're interested in, or do you want me to make a decision and rule? Because I can certainly do that. I've heard enough from both sides. And I can still hear from your other witness if you want. But she's making you that proposal. What do you think?
I would go along with her proposal. It makes sense, but I still think that the accusations, most of them were lies and exaggerations, but I would go along with her proposal, and I would like Kyle Engel to also talk to you.
Well, does that, if we don't stop now, Ms. McIlvaine, does that stay open?
Well, Your Honor, I really just want to resolve this for everybody, not have this continue on. If she's the defendant and if she's willing to do this, if Kyle Engel has things that she wants, my number was on this petition when we filed it, and there's ways to get a hold of me. We're certainly willing as an organization to hear what people have to say. But to resolve this is what I'm asking now, to avoid going into a lot more for this hearing. And also, I'd like for Eric not to have to sit through a whole lot more of this. So no, I guess it's open now. Otherwise, I'm going to withdraw and we'll just go forward.
Okay. So you've got a decision to make pretty quickly. You're welcome to call your witness and keep fighting the eviction, or you can reach this agreement she's offering you.
Discuss this with Kyle, and her advice to me and my attitude towards it is I will accept her proposal and Kyle will not testify.
All right.
Good call.
Now, is Kyle your friend? Is she your neighbor? Both?
She's both.
She's not a legal advisor, is she? She's not an attorney?
She's not an attorney, but she did work for the justice system in a courthouse, and she also worked for an attorney, so she has more knowledge than a typical person who has never done either one of those things.
Okay, well, good. That's good you've got her, so she can help you make the best decision about this offer that's in front of you, maybe the best you can based on what you have in front of you without your own attorney. All right, so based on what she's suggesting and what you come up with on your own, you wish to accept this offer to end the case now by agreement?
I wish to accept it.
All right. Well, Ms. McIlvaine, I'm going to consider this case is settled by agreement of the parties, and you will journalize it. You said you did have a couple of things you wanted me to rule on for this journal entry, though, if it doesn't work out.
Yes, Your Honor, on the restitution, if she's not ousted by October 15th, we want to have the ability under the statute to remove her, just so we can get down the road and go forward.
Not have to come back to court. Okay.
Yes.
Does that sound agreeable and make sense to you, ma'am, Ms. Vujkovic?
Yeah.
Okay. All right. Well, I will find that and order that as the reason, but I want to be careful putting you in that position you want to stay out of, which is a formal declaration that you have legally been kicked out of a HUD housing. I understand that is your big concern, and Ms. McIlvaine's her big concern is to just get you out and make everybody feel safe and so forth. So if we can reach that agreement, if you guys can reach that agreement, I'm not a party to your agreement, I'll be happy to approve that. But you better
just to clarify that we would then have another half month's rent, since she'd be there till October 15th, which would be $102.50.
Okay. What do you think about that? Does that sound fair?
Sounds fair. That's anyway.
All right. And when does that need to be paid?
So it needs to be paid by the 3rd of the month. So she's already paid for September, and I will go ahead and add that to our account for September, for the $205, and then she would owe $102.50 by October 3rd.
Okay, that would cover you through the 15th. That right?
Correct.
Okay.
Correct.
Is that what you agreed to?
I agreed with, however, in the lease it says we have till the 5th. And regarding the transportation program, I didn't really say enough about that, but that driver harassed me.
And she's wanting to move along to cut the short what the court. Yeah. So
you can have it till October 5th. October 5th is fine.
To pay, but to be
pay your $102.50.
Right.
Okay. And then with regard to the damages, Your Honor, I guess if you want to do a ruling on the refrigerator, otherwise, after she's moved out, we could then go forward on damages if we need to.
Well, we can do it either way. We can do the refrigerator now or just put it in and wait and see what happens after she moves out if you find anything else of concern. But certainly, I can and will rule that damages should be reimbursed to the plaintiff. And I'm going to let them have some time to get in there and look. And if they find some damages, and that's customary when you leave a rental, if you've damaged it, you should pay for it, and they should be given some time to find that damage. If you haven't, great.
And how about the refrigerator? Any damage specifically on the refrigerator that we've already, because that's already gone and left, and we know the damage.
Yeah, it sounds like that there was some pretty disgusting leakage going on in the refrigerator when Mr. Holmes took it out. And it sounds like it was being used to minimize the health hazards with the flies and the bugs. Sounds like you were trying to keep that under control by putting it in the refrigerator. And I'm surprised it didn't work a little better. Frankly, you would have thought they would have frozen some of that bug-infected material, but it didn't. Yuck. It only made it worse. So, and that's probably because the electricity went off.
And it got like
it was off for almost a month.
Okay. So what I will do is I will grant that portion where the refrigerator will be reimbursed to the deposit. And are you seeking more than the deposit? You are, aren't you?
Well, we are, Your Honor. You know, quite frankly, between her financial situation, she may not be able to pay it. But if we can at least get the deposit at this point on the refrigerator, that will bring us somewhat forward.
Could that be an agreement between the parties that you get the deposit and kind of
for the refrigerator? Yes, that would definitely be good with us if we could use that deposit on the refrigerator.
And then not seek any more damages on the refrigerator, limit it to the deposit. How about that? Do you accept that offer where they keep that deposit of $264 that was made on, I believe, November 15th of 23, and that will be applied towards the $799 on the replacement and the moving it around, but you wouldn't have to pay any more than that. You wouldn't have to come up with any more cash, as I understand the offer, Ms. McElmain. You'd be willing.
That's correct, on the refrigerator, damage on the refrigerator, yes.
Now, if you've gone in there and kicked in the walls, that's a different story. They may still be able to recover damage, but if you haven't done anything like that, then that would pretty well cover you. That would take care of the refrigerator, which right now is the only damage I know of, and it would be the big ticket damage. So do you agree to that you can settle the refrigerator issue by letting them just keep your deposit of $264?
Don't think it's fair, but I will agree to it.
All right. Well, as long as you agree to it and you're doing it without anybody forcing you to do that. Is this agreement all done at your own free will without feeling like you're being forced or threatened to do it?
Yes.
Okay. All right. Well, I'll make that part of the record. And then again, if that works for your client's satisfaction, Ms. McElvain, you can journalize that as well. And like I said, if you get in there and you find out she's kicked in all the walls and broken all the doors off the hinges, then we'll need to revisit that damage. You can or just tell you that you would be able to get in there and inspect and recover for that. Anything else I need to rule on right now, Ms. McElvain, as far as you're concerned?
No, Your Honor. Thank you.
All right. Thank you. And Ms. Boykovich, I keep thinking I'm going to learn how to pronounce that name before this hearing is over, but do you have anything else we need to address before I let you go? I'm not hearing you right now. Go ahead.
Regarding after I leave, I would like someone to be present when they inspect the apartment, because I intend to leave it better than it was when I got there, because all the cleaning was not done when I got there. And, I want to make sure that
Your Honor, we would go ahead. We will have somebody there as long as it's at a reasonable hour. That we can have somebody up there as to what the condition of the apartment is. When she signed the lease, she agreed it was in good condition and it was clean, everything. So we don't need to go into that. But we are certainly willing to be there when she moves out, as long as it's at a reasonable time and not like at 11 or 12 at night or something.
And I think that's certainly appropriate. And I trust you would agree to that as being reasonable as well, ma'am. That you can have someone there, but not at night. It'd have to be during business hours. 9 to 5 usually. Not those are any set business hours, but
And we're very flexible. We're willing to work with her, but only to a certain point.
Sure.
They're past that
Okay,
point
well,
now.
that'll work for you, won't it, Miss Vojkovic?
That'll be fine.
Okay, and you can put that in the paperwork too.
I will.
If it's a weekday 9 to 5 or whatever is reasonable. If you want to just make it as broad as reasonable, that's okay too, but that just opens the door, as you know, for more argument. But it sounds like you two have come to, it's been a while, it took us a while to get through this hearing, and we could go a lot longer on the hearing, but it sounds like you've come to a conclusion that to me seems reasonable and fair to both parties. So if there's nothing further from anyone, any reason why we shouldn't adjourn this hearing and conclude this trial?
No, Your Honor. Thank you.
All right, thank you, and thank you, ma'am. Yes?
Thank you, Your Honor. I think that you did a good job at justice.
Well, I appreciate that, and I'm glad you feel that way anytime you come to court. That's a good result. Unless the other side feels otherwise, and then they say that's a bad result. And there's some saying about that. In any event, I'm going to let you all go. Thank you all for your time and participation. And at this time, we are in adjournment. Everyone is excused. You can walk away, turn off your telephone, whatever you need to do. If you don't turn off your telephone, Missy can do it for you.
Missy took care of that right away. All right. I thought, I didn't think, at the end of this, I have a different impression than when I started. When we started, I thought that we just had a nosy neighbor that was that neighbor, right? It was that neighbor. We know which one that is. Her mental acuity, it's there. She's sharp. She's recalling facts and numbers and correcting things. And I think she does possibly have some issues with paranoia. But she's got a lot of her faculties there. She needs help. And hopefully she gets somewhere where she has that. But I can definitely also see why the apartment unit is saying we're done. We've done all we can, as they have a lot of people to think about. And Eric, wow. We've only got a couple minutes before we're due back in Thurston County courts, which are, well, going to be back from lunch in just a moment. Let's see, let's see if I can do this with my timer. Got 6 more minutes before they start. So if I go up here and I take 5 minutes off, let's see, timer, let's set. See if I do this right. I can set it to say, let's try that again. I just take 4 minutes off now, and then say set, and then play. I think it's right. I think that's right now. Still figuring out this verdict clock. That'll work. Did we get a verdict? No, we didn't. They're just coming back from lunch right now, so we're going to be going to courtroom after courtroom, looking for the happenings as they are occurring in our world of true crime. Let's see. Still have that one going for Judge Wolf. We don't want to go to that one. Wait for it. Judge Simpson's live. Let's go up there.
I believe so, Your Honor. Thank you.
I'll tell you at 9, okay? All right.
Preliminary examination in person, September 30th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Honor.
Thank you. Bond will continue. I think Burgess told him. I think he did. The people we came with, they got long pants on. How come? Never mind. Everybody just go home. Take care. Court calls the case. People versus Jacqueline Waitzel.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Paul Stablin appearing on behalf and with Ms. Waitzel. We're appearing via Zoom this afternoon, Your Honor. That's with Ms. Waitzel's consent.
All right. Mr. Waitzel, can you state your name, please?
Jacqueline Waitzel.
Thank you. All right. What are we doing?
Your Honor, at this point, we've been before the court on a number of occasions, and I'm asking that the matter be set for preliminary examination.
And so you have all of your discovery counsel?
I do, Your Honor.
All right. Would the people have their witnesses available on the 30th?
Yes, Your Honor.
Preliminary examination in person will be set September 30th, 2025, 9 a.m. That is it 9?
16.
At noon. That will be before me.
Your Honor, I am going to indicate to the court, actually noon will be fine.
Okay.
I'm sorry, Judge. I apologize. I'm looking at my calendar.
No.
Trying to figure out what's going on.
No, that's okay.
Here.
So it'll be noon before me on the 30th. Thank you.
Very good. We'll see you then. Thank you.
Court calls the case of the people versus Keith Walker.
Jennifer Douglas for the people.
Good afternoon, Your Honor. Christina Costantino appearing with and on behalf of Mr. Walker. Mr. Walker, can you state your name for the court?
Keith Walker. Thank you. All right. What are we doing?
Judge, this is a date and time set for PCC. At this time, we would be asking for an adjournment. I am attempting to negotiate a resolution that would keep this matter at the district court level, and we need a bit more time to do so.
All right. Probable cause conference will adjourn to October 9th, 2025, 9 a.m. or as your invite indicates. Bond will continue.
Misconduct. We're waiting just a couple minutes for the court to come back, hopefully with a verdict or question in that situation up in Thurston County. Reckless driving case.
Take care. Been real. I don't know him. I do. Was he with something else? Another game? Did I lock him up? Should I have? Never mind. Court calls the case. People versus Devon Watson. I didn't.
590 standing in for attorney Monty Kavajian, P 76143, representing Devon Watson to my right.
All right. You're stepping in his stead with his permission.
Absolutely.
Is that correct, sir?
Yes, sir.
All right. And you're requesting an adjournment?
Yes, we want to see if plea negotiations are successful.
Well, October 16th, give you enough time to get that done.
Absolutely.
Probable cause conference will be adjourned October 16th, 2025, 9 a.m. Bond continue. Thank you, sir.
Thank you.
And court recalls the case of the people versus Jeremiah Dillon.
Why is
Good afternoon again, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Dillon, who stands to my right.
Jeremiah Dillon.
All right. I now have a plea form that indicates that the defendant would be pleading. Okay, I see how we did it. That the defendant would be pleading guilty to 2 charges. Count 2 of operating while intoxicated with an occupant less than 16, the 1-year offense. Count 4, controlled substance use of cocaine, also a 1-year offense. Upon the successful plea to counts 2 and 4, counts 1 and 3 would be dismissed. That is the court's full understanding of the agreement. Is that correct?
That's correct, Your Honor. That is the provision of the initial plea offer.
Correct.
That is defense's understanding as well, Your Honor.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Jeremiah Dillon.
All right. Sir, it is this court's understanding you're going to plead to 2 misdemeanor charges. First charge is that of operating with a minor in a motor vehicle or operating while intoxicated with an occupant less than 16. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine, up to a $1,000 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary.
Okay, we're back. We're back. Let me get this ready. Need to go back to Thurston County on this channel. Thurston County Court. 4. There it is. Go back on 2. Here we go. Okay. Now we're good. We're back. And now they're gone. Why did they do that? I think they just turned off the live stream again. They started it and stopped it. We're back and then we're not back. Just the same little clip over and over. We think they have a question. We think there's a question. So, okay. I think. Yeah, they played for just a couple seconds. There was no audio. Just listen to see if anything happened during that time. Seems awfully dark in that court. Maybe it's because the bright lights coming in the windows have sort of made the camera iris down automatically. Okay, we'll keep the counter going. Yeah, they killed the live stream immediately, so maybe they're not ready for us yet. All right, we'll keep watching. Josh, thanks for keeping an eye on that. I'll keep this one just ready to go at a moment's notice. I think we have a question is what it is. So I'm not going to play the verdict music again, but I think we have a question in the court. Anyone know what the penalty is for reckless driving? Up to a year in jail, $5,000 fine, and 30 days losing your license. That's for Thurston. Martha, I have great mods. That's how I do it. I have fantastic people that help me, keep me straight and point me in the right direction. Someone playing the flute? No, my son is whistling. He's just a happy kid. He loves music. If he's not listening to music, he's making up music in his head. Okay. Do another quick check. Not back. Well, let's see. I've just got this one from a couple minutes. It still says live, which is weird. So this says live on it. Like if you go out, see right here, it says it's live. But you go in and it says it ended 6 minutes ago. Your YouTube doing non-YouTubey things. That's what it is. Now they say they're live again. They're struggling. Look, it shows live. It's not. Okay. Sign of a very happy little soul. He was a happy kid. Is Thurston going to stiff us again? No, don't even put that out there into the universe. Don't manifest it, or it might happen. We waited 2 hours on this trial. You think there'll be a verdict before podcast tonight? I think we sang Irish Blessing. I might have recorded that. The problem is I video recorded it, and we have family members who don't want to appear on social media at all. So I can't show you that. They're struggling with their feed. They're live for 2 minutes. Can you make YouTube not YouTube-y things in your AI stuff? I'm not sure what you're asking there. Probably. I rage on YouTube. They say I'm broadcasting, but I don't see my live. Hate them sometimes. Ayden Music Man, it's slow to update, I think, is the situation. So it is what it is. You have to go all the way out and search again, or else it won't see the new stream. All right, James says not guilty on this one, on the traffic case, the reckless driving, which I spelled two ways, W and R with the apostrophe, if you notice that in the title. Because she didn't wreck. Didn't happen. Josh, did you just email me? Yep, I see it. Where's this at? What courtroom is that in, Josh? I didn't read it correctly. Let me try it again. I make mistakes. Recovery Addict can make a YouTube, not YouTube-y things. Oh, Recovery Addict, can you make a YouTube, not YouTube-y things in your AI stuff? Can I? I still don't know what you're asking. Misconduct, I'm losing it. Write it again, but use a crayon and explain it as you would to a child. That will help me on my side. Try it with a crayon, yes. Big letters. Easy pictures, 4 colors. That's what I need. Just simplify it for me. Or call me on the burner phone and we can talk it over. So, it has been a long afternoon. It's crazy. I'm just watching for that new live stream that might start at any moment. And it hasn't yet. We anticipate the jury has a question. But I think the question is, what do we do when we can't agree? I think that's what it is. So it might be verdict. All right. I would understand better if it was a wax crayon. This context is searching for crayons. All right. Well, what do you think? We're an hour and a half in. Keep the timer on the screen for you at least. Hour and a half into the deliberations. They should be deliberating right now. Warren County, Ohio. I'll probably need you to remind me of the link when the time comes, Josh, but it sounds good. That's the there's a courtroom 3 in Warren County. That's the one that just streams 24/7, right? They just never stop. I mean, day and night. You can see the cleaners and everything. Misconduct. Are there going to be any more philosophical questions from the podcast tonight? I don't know. Is the stream planned for the pod? Yes, it is. I always miss it because I never see the thumbnail to notify me. Let me put it up. Well, that's what you're asking. Is the thumbnail up? Let me build it right now. First, I have to build the thumbnail image, which I actually update every single week. That's not it. Oh, I'm in Red's. I'm in Red Pen's account. Hang on one second. Leave Red Pen's team temporarily. Go to my team. This will be season 3, episode 34 tonight. If you missed all the others, please go back and watch all of them. Compress, download, StreamYard. I think I'm going to downgrade my StreamYard. Remind me to do that sometime. Maximize, minimize. That's cool. They're coming up with a few things. Can you say Happysboro? Or do you want me to say Happysburg? Which way would you prefer? Okay, the live stream is up now or at least the placeholder is up for the podcast, so you can click on it and be notified when it goes live. Let me just edit and change the image on it. Just one second. Thumbnail, podcast, save. Okay, so it's all good. All right, where are we on this case? We're trying to watch, see if it comes up. They are still not back. Downgrade. Did not think RA that was in your vocab. Mrs. RA will be shocked. It's a downgrade because it's a software program. It's not hardware. You know I'm all about hardware, technology, equipment. Software, not a fan. I currently spend $98 a month on StreamYard. I think I can chop that in half and still have the same product that you guys see. Let's see. Kayla, verdict on Jose, not yet. We still have closing arguments tomorrow morning. We've done everything else. The jury's received instructions, closing arguments, and then verdict watch after a tiny little bit of a charge tomorrow morning, and then possibly a verdict tomorrow as well. We're also waiting for a verdict here in this case up in Thurston County, Washington. It's an ambulance going by. You look and see if any judges in Western Kentucky go live during the day. I can't think of any off the top of my head in Kentucky. Anyway, if I can chop down what I pay to StreamYard in half, that, anytime you can reduce the bills, it's a good day, right? Let's see. My account. Billing. Account settings. Nope. If I change the plan, hang on, we're shopping together. I pay $89 a month. Right now we have the advanced program, which has 4K local recordings, don't need that. Multi-stream to 8 destinations, don't need that. Extra camera, oh, that's pretty nice. Like the extra camera, but don't need that. 15 backstage participants, don't need that. Pre-recorded streams, don't need that. On-air webinars with 1,000 viewers, no. Custom fonts, no. Download transcripts, no. And 4 seats, no. Well, possibly. I might need the seats. I need the seat. I need the seats. That's the one thing I need. Okay. All right. Wait for it. We're still waiting to see if we can get court to come back here in just a second. And no is the answer. Haysboro. Yeah, you've missed. You guys have messed up the language a little bit for being the Queen's English. That's pretty rough. That's pretty rough. Ask if you could just add it on. I think. Let me just see if there's. Multi-stream. Explain seats. Is that our command? Yes, it is, Cass. Exclamation. Well, no, it's not that one. It's not your seats. What it is it allows me to have someone else on as a co-host who has all the same ability to add people to the stream, to select text messages to highlight on the screen. So basically, it's Thomas's access. I don't want to take his access away. Jump back to Kansas. State v. Mefford. I'm not sure if this is one we want to follow. Hold on one second. Let's see. What is this one? Did we miss it?
All right, Ms. Medford, if this is reduced to, usually if it's an obstruct on apprehension with a felony, it's a felony. Like if there's a felony warrant or it involves a felony crime that's being obstructed. But if it's a misdemeanor, it can be charged as a misdemeanor.
Yeah, we missed that one. I'm not gonna go back to that one. Guys, I want a verdict here so we can be done and get, nice clear start on the podcast night. But what is the jury doing? They know that they can all watch the video at the same time. They don't have to take turns, right? I mean, I'm flabbergasted. Are they trying to get free dinner out of this? Maybe they think they get a hotel room. Weird things happen in Thurston County. I'm worried that they're like doing the verdict right now and they thought they're live and they accidentally hit the button twice and now they're just gone. But whatever you do, don't call. Don't call because who is it, Valerie? She might delete the whole thing if she thinks people are watching. Verdict is longer than the trial equals mistrial. Denisha, yes, if we do close out the live stream, it will promptly require them by law to start to bring the verdict back immediately. That's how it works. So what's everybody doing this weekend? We can talk about that for a little bit. Nothing special, not a heck of a lot. NASCAR, says Twubble. Firewood weekend, that sounds like hard work. Restoring an antique lamp. Football and cheer for my kids. I have no plans, says Auntie Birdie B. Just chilling. Going to turn some wood bowls on the lathe. Play on crime, thank you. Going to the beach. Fishing, of course, says Josh. Just relaxing. Just Kim. That's what you need to do, Jim. Just Kim. Focus on that. I called you Jim, which is combining Just and Kim together. Jim. Thank you, Denisha, looking out for me. Going to Duluth. Who was that? My daughter has cheer, football, crocheting. I think ECU is playing a big game here in town this weekend, maybe tomorrow. So, I don't know, maybe watch some football here too. Although I don't have tickets, so maybe I won't. Transcribing some sheet music to MIDI. You don't know how to read sheet music, which is a bit of a hindrance. Do you use Cakewalk, Agony Goose? Can you use Cakewalk? Or maybe, I'm sure there's an app that can read music for you. Beading and crocheting. Birthday on Sunday and working. Christy, happy birthday in advance. Enjoying a free weekend before the rowing season starts. And we have to travel. Waiting on the birth of my first granddaughter who was due yesterday. Linda Lou, it will be the longest weekend ever. If she's not born this weekend, I'm just telling you. There's nothing, I mean, they say a watched pot never boils. This is worse. This is worse. Tacos with friends. Melissa, thanks for the invitation. We'll be right up. Sounds great. Pretending to work over here. Thurston's live again. Oh, that's what I was looking for. All right.
Go off the record.
Are you serious? Let's go back and hear what this says.
That's what we're at here for today. So I guess I turn from you there, Ms. What your plans are, or
Yes, Your Honor.
we could just reset if you intend to refile or retry this case.
It's hung.
Speedy trial would start 90 days from today. And then we'd set a pretrial. I might set a pretrial here in about a month. And then you'll remain on the case. All conditions that were set in this case will remain in place. And
Your Honor, my understanding is that I should ask that trial dates be reset today, and that would be my request.
we can do that. But I think it might be worth it we can do that. Why don't we go out about,
And is it, so speedy restarts today?
I believe so, yes. Because it just goes back to ground zero.
You're seriously going to retry? Now she's going to face both charges. That
We
sucks.
just set trial for,
Because next time they will testify that there was a kid in the car.
why don't we go December 10th and 11th? Confirmation on December 5th. And we can set the pre-trial for sometime in October.
And Your Honor, I apologize. Confirmation was when?
I think I said December 5th. We'll just find a date. And then you should put that in the file there, Janice.
And
October 31st.
Your Honor, could it be reset within 30 days? I haven't been in a situation before, but the input that I'm getting from my colleagues is to ask that it be reset within 30
Sure.
days. I think it's possible we could reach a resolution.
What is it that's being reset within 30 days? The trial date or the?
I guess. Do you want the trial date reset?
Yes.
Oh my goodness.
I frankly, I'm not sure what the correct answer is, but
That's all right. It's all right. It's not worth arguing over. How about October 15th and 16th and confirmation on October 10th?
as far as I know, that should be.
I'm sorry?
As far as I know, that should be fine.
Okay. I'll go back and excuse the jury. Folks want to speak with them? Mr. Sheskin?
Oh, I didn't know that was an option.
Yes, particularly in this circumstance, it would be helpful to get some feedback.
Yes.
So go off the record.
And they go off the record. So I'm going to take a screenshot here really quickly. This is a screenshot. Let me do this because we need to. One hour and 45 minutes of deliberation, roughly. The jury taking almost twice as long to think this one over as it took for the prosecution and the defense to put on their case. And they come back saying, the six of us cannot agree. We cannot unanimously reach a verdict. We are hopelessly deadlocked. And there's no hope of that changing. The instruction that the defense attorney gave to the jury, they said it was most important that you should hold on and not change your opinion just to reach a verdict. Might have been the best instruction defense could possibly give today because they did just that and we have no verdict. This gets reset. This gets kicked back. This is called a hung jury. It's a mistrial. Hung jury resets everything to right where we were before this jury was selected. Probably all the same pretrial rulings, the motions to eliminate, everything else is identical. And looks like in October, the state says we'd like to retry this case. We'll bring it back. When they do, they will have both charges again. Just because it got thrown out during this trial doesn't mean it will be thrown out for the next trial, because we were set back to the point before that charge was thrown out. And I can bet you dollars to donuts that when they do retry this case, they are definitely going to call a witness that will testify there was a child in the car with Emily Fogelman when this occurred, and go for both charges. So the endangerment charge back on October 15th and 16th. We'll be back. The jury says we can't do it, Judge. We've tried. We cannot do it. It's a hung jury. That means at least one voted to convict and at least one voted not guilty. It could have been 5-1, 4-2, 3-3, 2-4, 1-5. Yeah, all those numbers, all the different, as long as it adds up to 6, that's what it could be, but it could not be 6-0. And because of that, we are done. We are done with the case up here in Thurston County, Washington. As fun as it was. See ya. All right, there you go. It's over. It's over, but it's not over. What were the charges? Reckless driving and reckless endangerment. But honestly, if there was a charge on the books that's called passing a cop, that's pretty much what it sounded like. So there was no acquittal. This was not a partial verdict. There was not. It was not like if the jury had come back and said we find her not guilty of reckless endangerment and were hung on the other charge, then she would have an acquittal and they could not bring the other charge. But the judge threw out the other charge. It never went to the jury, so there's no verdict in that one. They can retry the case. They could change all the charges. They could throw on speeding and failure to signal and whatever else they want to on this case the next time they go around. I don't think they will. I think they'll handle it exactly like this one, but they'll definitely have 2 witnesses. The sheriff was involved, and I think that changed everything. Thanks for including us in the trial. Can't wait till October, says Martha Ivy. What a gross waste of government resources. Josh does pick the crazy ones. Let's hear them with the jury. Can you believe it's actually 5 o'clock? That it's time to go home right now? That in 3 hours from this very moment, you'll be sitting here where you are now, watching the screen you are now. But I'll be here with Thomas at my side and a special guest as we kick off the Not Relevant podcast, which sounds something like this. Yeah, we're not going to play it because it's not time yet. It's not time yet, but that's pretty good. It's only 4 where I am, says Carol C. Well, then I get off early where you live. DAs make some choices that baffle me. Honestly, this seems like we tried, we didn't get it. We'll just drop the charges. I think she hinted at that. Like I would be, honestly, I'd be super surprised if this actually came back and they pushed for it gung-ho. Okay, they already did once and they couldn't get a conviction. It's not like they're going to get more evidence. There's no better jury than the one we just heard that can convict on reckless driving. They got all their evidence in. They got everything they wanted in, and they weren't able to convict. I think what they're going to do is offer a plea, and probably a very generous one. I'm not sure if they can plea from a criminal down to a traffic offense, but it's going to be fun. I need a lawyer to feel convinced that a JOA isn't an acquittal. Let me think that one over, Libby. Well, look at it this way. It's in the name, but the judgment of acquittal is only for that trial, and we're resetting back to before this trial began. So the decisions and even the testimony that was in this trial is not going to be the testimony in the next trial. I think it's that's my understanding. Libby, no, the judgment of acquittal is for the charge, not the trial. Nope, they can recharge everything. It's not because it didn't go to the jury. Yes, beginner crafter, that is, I think that's the core truth there. If you're acquitted, you can't be charged again. Well, it wasn't a JOA. First of all, we can go this route if we want to play a semantics game. In Washington, they call it a directed verdict, which I guess would make it sound worse that there was a verdict and it goes back. I think it's the fact that we're rewinding everything back to before the trial began. I think that's the key. If it was a jury trial, so the judge doing the JOA will still let it go ahead because the judge wasn't the fact finder, the jury was. But the judge was the fact finder for that charge and it prohibited it from going to the jury. You have to pick a new jury and go through all this. It's going to take another day. We've got maybe 2 days. I love when RA plays semantics. Let's not fight over a simple word. Of course we will. It was one of 2 charges, not all. It's different from a verdict. It's dismissing a charge. It's preventing a charge going to the jury in this one. You have the not relevant, not the irrelevant, not irrelevant. That's a completely different podcast, which I have no part of. But the not relevant podcast, I'm going to change the time to have it start at 8 p.m. Sorry, I completely missed that. Cancel StreamYard. Go back. Change the starting time. Just 1 second.
I'm not going to argue about semantics here.
Guess I have to do it in YouTube.
I think I'm about to catch a whooping.
There. It should be fixed now. It should be fixed in theory. James says, court is one of the places to fight over semantics. I think it's actually encouraged. Well, that's what lawyers do. They argue over words all day, every day.
You don't put a diplomatic plate on a hoopty.
You don't. Corey, yes. If you can find Jim, he will tell us. You didn't say dismissed, and if he
I was told counsel wanted to see me at sidebar.
He would have specified it if with or without prejudice. The jury had no role to play in the verdict or the endangerment.
There's nothing in the order that restrains you from talking to cats.
Thank you.
I turned the volume up just briefly, and you guys go haywire on it. All right, it's 5 o'clock. It's time to go home for me. Well, I'm already home, but it's time to walk into the other room and say hi to the people who live here.
In front of the Walmart.
Mm-hmm. So we're going to do that. We're going to be back tonight with the Not Relevant podcast at 8 p.m. What city or state was this trial? Autodoc, this one.
Now I'm trying to have court. You don't raise your voice again.
You guys, just hold on for a minute. This one was in
I don't like podiums, Your Honor.
Thurston County, Washington, like the state of Washington. And it was courtroom 4.
Going to address subject matter jurisdiction.
If you're curious. They have 4 courtrooms. It was the number 4. I think that's all.
I think I'm about to catch a whooping.
You guys are having too much fun. All right. All the sound effects are happening.
Thank you, sir. You're my new best friend.
All right. Tonight is the podcast, the Not Relevant podcast. Please join us for that. It's going to be a lot of fun. Special guest to be announced. And I think that's it. I think that's all. I don't have anything else for you. Tomorrow's going to be a big day. Tomorrow's going to be a big day. We've got closing arguments in the case. Well, I'm going to get rid of the Emily Fogelman one because she's gone. Why does it still show that on the screen, but it shouldn't be? Oh, because I'm in the wrong window. Okay. Got it. I fixed it. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. until we go live again at 8 p.m. with the Not Relevant podcast. I'll give you a hint on the guest. Are you ready? It's not me. I mean, I'll be there, but I'm not the guest. I'm the host. I'm here all week. You guys. It was a fun day. We will see you on the podcast because I'm the guy. All right. You guys be good to each other. We'll see you tonight. Be there early. We'll talk to each other longer. We'll see you. Bye-bye.
I think I'm about to catch a whooping.
Thank you, sir. You're my new best friend.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Hush. Now I'm trying to have court. You don't raise your voice again. In front of the Walmart.
I saw a chicken fight